I beg to mention item 20.
20.
Sir, this matter was regarding police protection on the eloped couple. And your lordship asked to see the connected FIR was
First,
court number 2. My lord.
certified copy.
The same is on open court dictated on 31st July, but still not uploaded, nor I should obtain the copy. So, my lord, one more date may perhaps may be given guidance.
Take a look at the learned counsel appearing on top of the petitioner. That the certified copy in respect to the order so passed in criminal petition number
170/2023
is yet to be received by the petitioner, and as such has sought for 2 weeks' time in that regard. This is the matter.
maybe after
On-
vacation. Vacation is there, my lord. Sir, vacation. Perhaps
Vacation is October? October vacation.
yes, ma'am. Because many other matters are pending yet not been uploaded, so it may take some time.
This court would not like to comment on that. We'll have it on 9th of September.
Pleasure.
This is the lordship. May please the lordship. Lordship, I'd like to mention an item for listing of mention an eviction item. Lordship for today.
Fiction.
Yes, lordship.
May I please,
Done.
your lordship. I beg to
Motion.
Yes, lordship.
mention on W of on 15/7/2024 for correction of the date, my lord.
Correction of a date in an order. Today,
Obliged.
tomorrow is closed.
Okay.
You have filed an application.
Yes.
Please, your lordship. Sir, item number 13. Your lordship.
1-3.
One.
List the matter before any other bench.
Police. I beg to mention supplementary list, item number 14. Being filed amended
Supplementary list item number. Number?
48.
What is it?
Amended petition filed today. Kindly the matter later.
There is a stay. Even the matter reaches if you are not clear on that.
A week later. 1 week later.
What?
1 week later. Listed maybe.
No. Whether there is a stay.
Yes, maybe.
No stay. Allocation file. We'll take it up. If it is, there is a stay, no adjournment. If there is no stay, adjournment to be listed after October vacations.
Regard to item number 31, the lordship, senior counsel, MJ problem today.
31.
And 31, yes.
Yes, tell me. Who has any problem?
So MJ Dhammet has some problem.
Huh?
Senior counsel, Mr. MJ Dhammet has some problem today.
Oh. The council. No senior council adjournments. Senior councils are no adjournments. I don't grant. They any other ground I will, not for senior councils. Yes, next. No other.
I'd like to mention for listing. The pertains to
Non-payment of
under MC and
a bench 4 matter. Not bench 5. Okay. The request of the learned counsel for the petitioner who seeks time for filing the amended writ petition. Matter stands adjourned to be listed after 4 weeks. Yes, what is this?
Lordship, this is a contempt against the order dated 8/5/24, Lordship. That is page number 19. Page number 22, Lordship. Here the petitioner has filed a complaint before the competent authority to cite this matter as the 17 biga of the petitioner's village land, Lordship, that has a period.
Which order,
Lordship,
madam?
8/5/24.
Eight,
8/5/24, page number 22, Lordship.
26,
22.
which is the relevant portion?
Paragraph 9, page number 25. That has not been passed by the competent authority, Lord. They have submitted a representation, that is page number 27, Lordship. Duly received.
AAC council here.
The representation also, Lord. For the reminder.
Notice making it returnable on 11th of September 2024. Not 11, make it 18th of September 2024. Directed to take steps by way of registered herein have approached this court alleging that the respondent herein have willfully and deliberately violated the order passed by this court dated 8/5/2024 in WPC number 2342/2024, wherein there was a specific direction to dispose of the land complaint case number 4/2022 by passing a speaking order within a period of 2 months from the date of service of the certified copy of the said order. It is seen that the order passed by this court was served upon the respondent on 17/5/2024, and it was also subsequently and subsequently there was a reminder issued on 23/7/2024. Taking into account that no steps have been taken, the petitioners have therefore approached this court seeking for initiating contempt against the respondent. The respondent is directed to file their affidavit, is directed to bring on record their stand by filing an affidavit as to whether the order passed by this court have been whether have been complied with or not.
Please, Your Lordship.
Okay, order dated 25/7/2023, page number 80, Lordship.
Page number
80. The past review petition, Lordship. Poetic portion is page 81, paragraph 4. Eighty-three, Lordship, I have submitted the certified copy on 4/8/2023, Lordship. Order at page 47, 46.
what?
Still, read petition order, Lordship, 46.
What is this? Page 80, 81,
Page 83 is my representation, Lordship. And it's
81, 81.
one is the order in passing a review petition.
So there you want the non-compliance of this, na?
Lordship.
Notice making it returnable on. Why you are making the additional district commissioner?
Revenue, Lordship. He's
Huh?
additional deputy commissioner revenue, Lordship.
Why you are making him a party?
Carrying the Lordship report.
And the direction was given to whom?
Respondent number 6, Lordship, originally.
Deputy
That's the
commissioner.
commissioner.
Then why you are making the additional deputy commissioner a party? We are not issuing notice upon number 2.
Lordship.
Notice returnable on 29/2024. Pustak. This court, taking into account the order dated 25/7/2023 in a review petition number. What is the number? What you have enclosed, nobody knows. Huh?
7, Lordship. Oblique
67/2020 is not inclined to issue notice upon the respondent number 2, taking into account that the direction was only to the district commissioner Hailakandi. It is also seen that the notice was only issued the copy of the certified copy of the order dated 25/7/2023 have only been served upon the office of the Deputy Commissioner Hailakandi. Under such circumstances, the notice herein is only issued insofar as the respondent number 1 is concerned. The case of the petitioners herein is that there was a direction passed by this court by an order dated 25/7/2023 in review petition number 67/2023, wherein there was the district commissioner Hailakandi was directed to make a fresh land valuation report with regard to the rate of compensation payable to the petitioners in Hailakandi bypass area by classifying the lands into 2 or more categories, that is homestead land and arable lands, etc., in terms with the award of the arbitrator dated 1/7/2017. It is also seen that this direction was to be complied with within a period of 3 months from the date of receipt of the certified copy of the order. The records further reveal that on 4/8/2023, the certified copy of the order was served in the office of the Deputy Commissioner, Hailakandi. However, as within the period so prescribed in the order dated 25/7/2023, the fresh valuation report having not been made by the respondent herein, the instant contempt application has been filed for initiating contempt against the willful and deliberate violation by the respondent. Full stop. Respondent herein is respondent number 1 herein is directed to bring on record their stand as to whether the order passed by this court on 25/7/2023 in review petition number 67/2023 have been complied with. The said affidavit be filed on or before the next date.
Right. What rate?
Yes.
Unfortunate lady lordship was evicted and her house was demolished by her Fatta land lordship.
What?
She was evicted lordship and her house was demolished lordship. Page number 17 lordship.
You've been evicted
Lordship. Page
from your
number-
Patta land.
Yes,
When?
14 lordship.
14?
14 February lordship. Lordship, page number 17. My name is there lordship. Till number 15.
17. What is your name?
My name is Tafu.
Tarfuza Khatun and Afuza Khatun.
Yes, lordship.
Afuza Khatun, Izzat Ali.
Yes, lordship.
You are the owner of how? What land?
The page number 16 is the order, lordship. The circle officer order.
Read.
Under remarks column, lordship. Tag number 403, Dagor Mati Uttarathikari Putre. So and so Stolot. The names are there and my name is also there because I am a wife of Amjad Ali, late Amjad Ali, lordship.
Where?
Ojuba Khatun, lordship.
Huh?
Page
As per the
16,
order
lordship.
of the circle officer, the name of Anima Khatun,
Onima, these are the daughter and
Kamala
son
Khatun,
and two wife
Afiza
of Amjad Ali,
Khatun,
lordship.
and so have been replaced in place of Antez Ali as his legal heir in Dag number 403. What is this Dag number 403 or Patta number 15? And what about the other people?
They are living like
So
entire lordship.
only they have to pick and choose in you.
Lordship.
Eh? How is it possible?
Lordship, 20,
How much is the land?
22 lesser only, lordship.
22 lesser. The total land here is how much? 3 bighas?
3 bighas,
3 katta,
3
16
katas and
6 lessers.
6 lessers, lordship.
6 lesser.
Amongst those entire land, my portion is 22 lessers, lordship. I'm living here, there, lordship.
Why they have taken your land?
They have served notice, lordship.
Huh?
Have served notice, lordship.
Where is the notice?
I appeared, lordship, page number.
You are illegally
19, lordship.
occupying land by constructing dwelling houses on Dag number 405.
This is regarding 405. I am 403, lordship. Several times they issued notice. I appeared, lordship. I submitted my documents, lordship. Last
Understood, but then also they have done it is only as regards you have 405, huh?
which is on 403.
403.
Yes, lordship. I am the pattadar of 403, lordship. Last,
Then you were given a hearing.
yes, lordship. I submitted my.
Then why should this court interfere with all these things?
I have submitted my documents regarding 403 saying that I'm living in 403. Last notice was 7/2/2024, lordship. Then to 14/2/2024 they came, the circle officer came and demolished my house, lordship.
At 403,
403, lordship.
not 405.
So 5, lordship. That is the she's an
Then why haven't you approached the deputy commissioner?
lordship. I have submitted all the documents before the circle officer.
Then why not to the deputy commissioner? Why haven't you approached that? Look here, this is the order he has passed. There was a hearing conducted. And after that hearing, he must have passed some order.
No order has.
No,
I
no,
know
some order must have been passed after. Why? How can after a hearing? Why? How can it be?
last notice was 7/2 and they demolished on 14/2.
I think you were asked to submit. You have submitted. You have submitted your hajira. There were certain hearings being conducted, and then thereafter some order must have been passed. And if some order is passed, why haven't you moved the deputy commissioner? Or against that, why haven't you moved the deputy commissioner? Look here, this is the it. Why should this court at all interfere with these type of litigations?
That case, I will have to take instruction whether
Please do. How much time?
one victim
Fantastic.
is an interpreted
The
rating.
learned counsel appearing on behalf of the petitioner seeks for an accommodation for a week. This the matter again on 21st of August.
That case has already been dismissed.
Huh?
Similar case has already been disposed of. So in that line, my lord, it may be closed. There are earlier writ petition.
Oh,
date, but
this Vivekananda Road.
yes, that order has already been passed. Oh, sorry, page 58.
Yes.
Yes,
Was the same order.
yes, ma'am.
Here is a case where he's. Why is it required to pass any order at all? Entertaining the instant writ petition and the article taking into account the respondent have categorically mentioned that the land were demarcated and thereupon steps were taken for construction of the drain. We have observed that the second any land of the petitioner would be at liberty to approach the referral, and in that regard, the concerned authority duly shall take for redressal of the grievance. Then, what is there?
On the same line,
I will only pass an order to that effect that taking into account that in a similarly situated writ petition, an order has been passed, this court is not inclined to entertain the instant writ petition. That is the only order where they have categorically mentioned this. And when did you file this? 5/8.
actually on that day, when your lordship passed the order, on that day,
On that day
Yes.
itself you filed.
on before that,
Hello,
one
Rabha.
day before I
I have
filed.
Mr. S.K. Ghosh, the learned counsel appearing on behalf of the petitioner. And full stop. Mr. Ms. So appears on behalf of the Revenue Department of the Government of Assam. Mr. B. Chaudhary appears for the respondent number 2 and 4. And Mr. J. Hendick appears for the respondent number 3. Full stop. The petitioner herein claims to be the owner and possessor of a portion of a plot of land measuring 4 kata 5 gondas covered by Patta number 195,
Tag number,
covered by Dag number 403 and included in Patta number 195 of Pargana Borakpar, Moza Tarapur, part Roman 7, on the basis of a purchase.
there is another tag that I have forgot to mention, annexer 1, 602 also.
You've forgotten to mention, forget it.
It is documented there.
So what? Document has to be verified on the basis of an affidavit. And the affidavit is not there. Why should I? Anyway. Part here by way of purchase by registered deed number or by way of purchase. Full stop. During the course of the hearing, Mr. S.K. Ghosh, the learned counsel appearing on behalf of the petitioner, submits that there is another plot of land at measuring where? Another dog where?
1 page 11,
That is what? That is the same dog.
602.
Earlier was what?
I have
And
wrongly
so
mentioned.
601 you have not mentioned. 602 no document. 603, which is the document?
603 wrongly mentioned instead of 602.
Say that, another plot, why you are saying that?
No, and not.
It has been submitted, 195 to 602, dark number, dark number 602 part, and included in 195. Second RS, patta number 195. Okay? It is the case of the petitioner that the respondent authorities without carrying out any demarcation have taken steps for widening of the Vivekananda Road and thereby trying to encroach upon the patta lands of the petitioner in the name of widening of the Vivekananda Road Silchar, that too without following the due procedure of law regarding acquisition and requisition of the patta land. This court duly takes note of that a similar dispute, similar issue had cropped up before this court in WPC number 3504/2024, and an order was passed on 5/8/2024 itself. After taking due note of the instructions produced by the Additional District Commissioner, Silchar, dated 3/8/2024. In the said instructions, which have been duly mentioned, in the said instructions, the contents of which is duly reflected in the order dated 5/8/2024 passed in the said petition. It had been mentioned that the construction work for the drain was undertaken after proper demarcation by the LR staff of the office of the assistant settlement officer, Sadar Circle, Silchar, and with the support of the local committee of the area. It is also mentioned that the due demarcation was carried out prior to initiation of action for widening of the Vivekananda Road, and the assistant settlement officer had demarcated and ascertained the government Caste land pertaining to second RS, government Caste DAG number 3321, 3322, 3323, 4279, 4280, and 4281. In that view of the matter, this court, while passing the order dated 5/8/2024, did not find any good ground for entertaining the writ petition which was filed. However, it was observed that in the circumstance any of the land of the petitioners are taken, of the petitioners therein were taken, the said petitioners would be at liberty to approach the concerned authority, and in that regard, the concerned authority shall duly take appropriate steps for redressal of the grievance. As the facts involved in the instant writ petition are similar to the facts which arose for consideration before this court in WPC number 3504/2024. And there has been nothing shown by the learned counsel appearing on behalf of the petitioner that to distinguish the facts of the instant case with the said writ petition, which have already been disposed of on 5/8/2024. This court is also of the opinion that the instant writ petition cannot be entertained in the present facts. This court, however, observes that in the circumstance that the land of the petitioner in any manner the petitioner is taken by the respondent authorities, the petitioner would always be at liberty to approach the concerned authority, and in that regard, the concerned authority shall duly take appropriate steps for redressal of the grievances of the petitioner. With the above, the instant petition stands disposed.
My pleasure.
Hmm.
Your Honor, petitioner is the owner of the plot of land and he is currently 78 years old. And he wanted to give this certain plot of land to his son. And for that, under section 21A of the Registration Act, there is a requirement of taking NOC, Your Honor. When he applied for the sale permission, that is.
Where is the portal? Show me.
Seva Setu portal.
Huh?
Seva Setu portal.
You must have taken a screenshot.
It is on page number.
There is an objection
20,
against the
yeah.
plot of land cannot apply for NRC for transfer for immovable property.
It is on page number 20, Your Honor. There is no reason mentioned why this objection is given and nothing, not that proper address is given. It is only name of the objectioner, Sanjay Ghosh, Dakhingaon, Guwahati, Kamrup Metro, and nothing else is given. Neither the phone.
Yes, Mr. Hendrik,
Take instruction.
understood. We will take instruction, but what is this type of objection? If you have any objection, you tell him that this is the objection and under such circumstances, kindly meet these objections. But can you put it out there in the portal? Look here, you cannot get NOC. Are he has a right. Are you not violating his rights under Article 300A? What instructions?
They have to allow the informed of the concerned one of parties.
We dispose it of.
Okay.
No instruction business. We direct them to, okay, if you have any objection, inform him. What is the objection? And he will, if the petitioner will try to meet it. Isn't it? But you cannot keep it out there, objection. Something like a virus out there. Yes, Mr. Counsel, what is your name?
Came on.
So and so appears on behalf of the petitioner. Mr. Ms. So and so appears on behalf of the respondent number 1, and Mr. J. Hendrik appears for the respondent number 2 and 3. The taking into account the facts involved, this court takes up the instant writ petition for disposal at the motion stage. The petitioner claims that he is the owner of a plot of land measuring 13 lechas covered by dag number 10 old 264 new and included in patta number 1 old 16 new within the revenue village Dakhingaon under Moza Beltola in the revenue circle within the school revenue circle in the district of Kamrup Metro, Assam. The petitioner had decided to gift the said plot of land to his son out of love and affection. However, taking into account the provisions of Section 21A of the Registration Act 1908, insofar as the same applies to the state of Assam, the petitioner applied for permission from the Deputy Commissioner, Kamrup Metro, through the online portal. Full stop. However, while applying for the said NOC, the petitioner have been informed in the online portal that there is an objection against the said land and as such cannot apply for NOC for transfer of the immovable property. Thereupon, the petitioner submitted a representation to the respondent number 2, which however fell into deaf ears. It is under such circumstances the petitioner has approached this court under Article 226 of the Constitution. This court have heard the learned counsels appearing on behalf of both the parties. The right of the petitioner and have given an anxious consideration to their respective submissions. The right of the petitioner over the land in question is a right under Article 300A of the Constitution. The law, in terms with the Transfer of Property Act, the petitioner has a right subject to having the petitioner has a right to transfer the said land, transfer and or convey the said land subject to the petitioner having right, title and interest over the said land. The responding authorities cannot take away the right of the petitioner without due process. Else it would be in violation of Article 300A of the Constitution. This court further takes note of Section 21A of the Registration Act 1908 as applicable insofar as the state of Assam. The said provision postulates that that no registration officer shall register a document as regards transfer of an immovable property without the NOC issued, without the no objection certificate issued by the Deputy Commissioner or such other authority duly empowered to do so. It further mandates that such application has to be decided within a period of 30 days. In the instant case, it is seen that the petitioner's application for no objection, which is required to be applied in view of Section 21A of the Registration Act insofar as it applies to the state of Assam, have not been accepted in the portal, stating that there is an objection. The said cannot be done so. In the opinion of this court, taking into account the mandate contained in Section 21A of the said Act, the respondent authorities are statutorily obligated to complete the process of disposing of the application within 30 days from the date of submission of the said application. Taking into account that the petitioner's application is not being accepted by the portal, this court directs the petitioner, grants liberty to the petitioner to submit the application before the district commissioner in an offline mode. And in this, and taking into account the mandate of section 21A, the respondent authorities shall dispose of the said application within a period of 30 days from the date of submission of the said application. If there is any objection as regards the transfer of such land, the petitioner be duly informed so that the petitioner can meet the said objections. Full stop. Anything more? With the above the instant petitions.
Hello, please.
6.
Please, your lordship. But the petitioner is aggrieved by construction of an boundary wall. My lord, in contravention of provision 41 of the Assam Notified Urban Areas other than Guwahati Building Rule 2014. And my lord, accordingly, the petitioner
Who has constructed a boundary wall?
my neighbor, my lord, private respondent number 7.
Why? Why are you aggrieved?
Not that is a poor quality boundary wall, but most importantly, my lord, the wall, my lord, as per the specifications provided under Rule 41 of the 2014 rule, my lord. The boundary wall is approximately, it has to be, my lord, 5 feet tall, my lord. But it is about 9 feet tall, my lord, construction. So I have written representations before the, my lord, Borpeta Road Municipal.
On one hand, you should be happy it is of poor quality.
My lord,
It will get broken off.
and
It will
My-
fall down. And on the other hand, you are saying that it is 9 feet.
my lord,
Then
the
which one do you want?
permitted limit is, my lord, 5 feet, and my lord, in exceptional, it is 7 feet. If, my lord, the other 2 feet is, my lord, it has to be open, my lord, transparent, like my lord, it is constructed by, my lord, the rod.
And this 9 feet or 7 feet from where?
I,
Height from
my lord,
where?
I have, my lord, from the level of the, my lord, road. Road, my lord, it has
Where is it? Show
41,
me.
my lord, center line, by
Where?
41 says, my lord, it has to be,
Because if your land is down,
my lord, then,
his land is high,
my lord.
then
then,
if
my lord,
we,
from
just for
center line-
example, his land is 4 feet above your land. It may be,
My lord,
then it will be only 1 feet boundary wall. It can't be.
why, my lord, it is provided under rule section 41 that from the center line of the road, my lord.
Let us see that. Where is it?
Lord, is page 286 of Assam Notified Urban Areas Building Rules 2014.
Where can I get it?
এখন আছে নেকি? মোৰ ফোনে দি-
Where is his permission?
But I have filed representation before construction, my lord. I have filed representation before the, my lord, Borpeta Municipality Board, but it was unheard.
Before construction, how did you know that he will make it 9 feet?
Constructing, my lord. But after that, my lord, it was constructed. I informed the chairman.
Except with the
Borpeta
special
Road.
permission, the maximum height of a compound wall shall be 1 meter above the center line of the front street. Compound wall up to 2 may be permitted if the top 0 type construction for the top plot. The height here shall be restricted to a man.
Second clause, my lord, 1.5 meter plus 9 meter is 2.4 meter.
Good idea. Hello, let us issue notice.
Not my, answers I have already placed before the chairman, board, Borpeta Road Municipality Board. Subsequent to, my lord, construction of the wall, my lord. Then, my lord, I
We
filed
issue
a
notice.
representation, my lord.
We issue notice only.
In the meantime, my lord, tendency of this state petition may not be a bar to consider. That is possible.
Absolutely no. Other people, other judges give, but I don't give such type of thing. Because if you are before this court, why should I ask them to consider? Then this is not the business of this court. We will make it a short notice. You take custody service, we'll take it up. Issue notice, making it returnable on 9th of September 2024. Petition, Mr. How can a state of Assam be represented by the deputy commissioner?
One is,
My goodness. Did ever heard of the deputy commissioner representing the state of Assam? This type of petition cannot be envisaged. File a fresh one. You can't make the deputy commissioner representing the. Do you know who is the deputy commissioner?
No, ma'am.
He's the head of a district.
Yes, madam. I don't think-
To be represented by them. The learned counsel appearing on behalf of the petitioner he may be permitted to withdraw the instant petition in view of certain formal. However, submits that like to refile by removing the form. Taking into account the above, the petition stands closed. The petitioner is given the liberty to refile by removing the.
Deeply appreciate.
Yes, what is this?
Mr. Lordship. I'm from the influent order, which is annexure 5, is the extension of an chief executive member of an Rabha council member.
Extending the term of the general council. Sound going up. Okay,
Yes, earlier to this
where,
presentation.
which order? Okay, where is in the first setting of the
representation
present so and so
which is annexure 2.
was held. Yes,
Annexure 4, where against this Professor Rabha, the vigilance inquiry has been annexure 4.
what is that? We are concerned with the extension being granted. We are concerned only with the extension being granted.
Already a representation against the Professor Rabha has been filed annexure 2. Against which,
Why are you
against which
intermingling everything?
the
Tell me.
annexure-
One is a case as to whether extension should be granted or not in exercise of the powers under 7(3). That is one aspect.
Yes.
Other aspect is that you want the cancellation of a caste certificate of somebody else.
Actually, he's not a Rabha.
Yes.
So,
Why, Mr. Counsel, then don't bring everything which is under the sun in missing autonomous council within the sphere of this repetition? My goodness, you can't do that. There are limits. Then which one do you opt out?
that as a already a vigilance complaint is against
No.
going on.
Which one do you want to opt out? There cannot be two causes of action which are completely distinct and different. One, you want the caste certificate of somebody to be removed. Very well. That is another aspect. On another hand, as regards granting of extension,
Then a caste certificate is the main here,
then why are you asking for that 6(8)? So you don't want?
which is after annexure 3.
No. Do you want 6(8)?
6 is also one of the part of it.
No, it cannot be a part. How can you make it both a part? Tell me. Give me a good reason. A caste certificate is on a different pedestal
Yes.
from us.
Already an
extension given.
inquiry is going on here against the chief executive.
Then why do, how can this court say anything out there?
Now, if-
Take action against cancelling his caste certificate, which was produced by him to hold the post of so and so. His certificate has been cancelled.
Investigation going on, submission of a vigilance.
Who is
petition,
investigating it?
Investigating, yes, to the director of a tribal affair plane, Assam.
Who is investigating? Oh, Mr. Dhor.
Well, there is a vigilance cell, my lord, that undertakes the inquiry, my lord. That is going on.
That is, I know. Yeah, Mr. Dhor is doing. So he will do. He will come up with such a thing out there. You don't need to worry. Mr. Dhor's department is very good in cancelling caste certificates. I hope you maintain the same, the same yardstick. Huh? He'll maintain it, I think.
Yes, you have to.
Huh? Sir? Don't worry. Why you are taking this? It will be cancelled. They maintain the same yardstick. They won't
been
bother
extended.
about Madhuri Patel or anything. They will cancel it. So don't worry about that. That department will help you out. Leave this prayer. Now let us come. Which prayer now you want? Can't come up with like this.
During this pendency of an investigation, extension is going on.
So how that is completely different. It is being given, I would have understood. If it is the horse 7-3, then 1 year period is there, then also they have gone beyond that. I would have understood. But we are concerned with there is a reason that the Assam Election Commission says that no, we are not in a position to hold it unless such an extension of 6 months is being given. Earlier 6 months was given, another extension of 6 months. If they go beyond this 1 year, obviously you will have a good case. You don't have a case for that. As of now, what is your justifiable reason? Can you hold the election?
Oh, yeah.
Then who is the specialized authority who is going to hold it?
Expedite the
Which one?
caste certificate, yes.
They are already doing it. They have a vigilance. You have Mr. Dhor's client. They'll do it. I have more faith on that. Don't worry with that.
Your lordship may time frame.
Why time frame? Madhuri Patel categorically gives a time frame. Within that time frame it has to be done, isn't that? Madhuri Patel categorically grants a time frame that within 6 months or something it has to be completed. Now, is it in violation to Madhuri Patel's? Huh? No. Then you don't have a case. I will record. Mr. Dhor will do the needful so that the petitioner's grievance is being duly done. Cancel it. Applying the same yardstick. Huh?
All aspects, my lord.
The committee has a what? To whom? No, you don't do that so that the matter again comes to this court.
My lord,
You should have good faith in this department. They are going to do it. Show me where the Madhuri Patel it says about a period. What is the period within which this?
Ideally, it was 2 months, madam. As for Madhuri Patel, ideally, it has to be 2 months, madam. Investigation.
Whatever may be, this investigation is mandated out there.
my lord, it is go to the
No, we will record it. That as per Madhuri Patel, you are taking action, so he doesn't want to press it.
Yes, madam. In
And
fact,
he will be at liberty to
Exactly.
again come.
my lord, my only submission would be, my lord, I am appearing for the General Counsel of the Rabha Autonomous Council, my lord. He has already preferred an application in terms of Madhuri Patel exercise is being going on. In my humble submission, my lord, his only purpose of filing this writ petition, my lord, is to, my lord, invoke his extraordinary jurisdiction so that it is being monitored by this court or
No,
being direct-
no monitoring.
proceeded in a one direction, my lord. That is why he wanted to extradite.
As per Madhuri Patel will come after the state council, Mr. Dhor's client passes the order.
Exactly, and there is a private respondent, my lord, against his certificate is under challenge. And most
Court is not
important
going
thing, my
to
lord,
do.
will kindly appreciate one thing, my lord, and as per Rabha Autonomous Council Act, my lord,
Huh?
it is, as per Rabha Autonomous Council Act, my lord, it is not that the Rabha person can only be elected to the general council, any scheduled tribe, my lord. He is saying that this gentleman, respondent number, I suppose 6, is not a Rabha person. Rabha, he doesn't belong to Rabha community. He's not a, doesn't belong to Rabha, community. But to which community he belongs, my lord? If he's otherwise a scheduled tribe, my lord, then also he's entitled.
No, but if he is a civil type, where is the question of cancelling his caste certificate?
He says, my lord, he is not Rabha. He doesn't belong to Rabha community. But there are so many communities in Assam who belongs to scheduled tribe, my lord. And Act says any scheduled tribe, though the name is Rabha Assam Autonomous Council, my lord, any scheduled tribe can be elected to the general council. So he has not suggested that this person doesn't belong to Rabha. He belongs to general, he belongs to OBC, he belongs to SC. Well, they have waited since 2013. This person is holding this post since 2013. He was elected twice. He was signatory of the Rabha Accord with the government of Assam. For last 25, 30 years, my lord, no allegation about his, my lord, belongingness to Rabha community.
Oh,
But his locus is seriously doubted, my lord. And there is a judgment, my lord.
he has got strengthened from what Mr. Dhor's client has done earlier with that Novosorania thing.
Yes, sir. In
That
Ayutthaya
is why he is also getting that thing.
he is getting the power, getting the my lord, enthusiasm
No,
from
getting
Rabha.
encouraged from that department. Yes.
was a different case, man, altogether.
No, his case is that he is not a rabbi, he is a Soronia. That is his case. That is why I'm saying
Well,
he
even
got encouraged. from you.
Soronias, my lord. Boros also. Soronias are Boros also. In respect of Novo Soronia, it was found to
Understood,
be
but
Decca.
what is your stand in that case? He must have been encouraged with that, isn't that? Because you see the timing within which it is filed. It's
Exactly.
just after that order which has been affirmed by the single bench,
And in Ayutthaya,
25-4.
Yes.
You encourage this type of litigation.
Just for the cover, then it will go inside the judgment.
No. They are encouraged by you, your department.
there is a judgment of
Anyways,
Ayutthaya.
this whatever maybe has to be taken note of by the authority. And the authority will look into it.
Yes.
Okay. As per Madhuri Patel. Will dispose it of.
But there is a
Not
private
withdraw.
respondent here, man.
That this will be looked into by the authority representation in terms with Madhuri Patel. That's all. Do you have any problem?
And only thing, there is a
And
private
the
respondent.
problem, only the thing
There is a
that
private respondent. Chief
private
executive member, he
respondent.
is a party here in
I'm
private.
not touching on anything. I'm only saying that this has to be done.
Done in terms of.
They have already filed.
Very good.
There is a law laid down by Madhuri Patel. They will follow it. Whether to reject his application, whatever you do, do it. But it has to be done within 2 months, nah? One.
Vigilance is 2 months.
Then thereafter,
And after it will go to scrutiny committee. State level scrutiny committee.
understood. So he gave it on 25-4. Why is it taking such a long time?
Sorry, case it took 4 years to decide. And South Korea just 20, the application that complaint was made, and the committee could complete the entire proceeding by law in 2024 January. Because my lord, once we get the
So
investigation,
are you saying that you'll defy the orders passed by the Supreme Court, the guidelines? The Madhuri Patel does not apply to the Plains Tribes Department. No, we'll say, record it. Because we have done in another case for one Rabha Soronia 4 years, so here also we'll do it because the petitioner is encouraged by that judgment. Tell me.
Look, may I submit something, my paragraph,
Yes, where is Madhuri Patel?
yes, paragraph 12, 13, my lord. Sub paragraph 9 and 10, my lord. But interestingly, my lord, Madhuri Patel was in the context of certificate using for educational institutions and jobs, my lord. That's why, my lord, this page 256 will be relevant, my lord. Paragraph 13, subsection.
But then also, maybe for that, but they have made it that this is the mandate.
Yes. that has
How
been happened.
you are going to do it?
That has been applied to other cases also, my lord.
Because there is also a mandate given to the High Court also to dispose it within 3 months.
Yes, ma'am. Paragraph 13, subparagraph 8 and 9 and 10, my lord, page 256, my lord. This was
Where are-
regarding enquiry, my lord, not about the entire proceeding. Enquiry is to be done by
Is
vigilance cell.
contemplated in para
Enquiry should be
6
completed
condition.
as expeditiously as possible, preferably by day-to-day proceedings within such period not exceeding 2 months. If after enquiry, the Caste Scrutiny Committee finds the claim to be false or spurious, they should pass an order cancelling the certificate issued and confiscate the same. It should communicate within 1 month from the date of conclusion of the proceeding, the result of enquiry or the parent guardian to the parent guardian or the applicant. In case of any delay in finalizing the proceedings, and in the meanwhile, the last date of admission into educational institution or appointment to a officer post is getting expired, the candidate be admitted to the principal. and such-
Mr. Goswami, tell me, how do you initiate the action? This proceeding will, an inquiry will be preceded on the basis of some complaint
Complaint.
or otherwise?
Yes, ma'am.
How, what is mandated of the Madhuri Patel?
My lord, Madhuri Patel is not about complaint, my lord.
No. When do you take it? The cognizance of an action to be taken?
Yes, if we go by Madhuri, that's why I'm saying, my lord,
Yes.
if we go by Madhuri Patel, it doesn't envisage filing of a complaint, my lord.
Then how will there be?
That's why it was in the context of getting or not getting a certificate or obtaining a certificate for school admission, my lord. It was, the judgment was on that. If my lord kindly comes to paragraph 13, main paragraph, my lord. Paragraph 13, my lord, page 254. The admission wrongly gained or appointment wrongly obtained on the basis of false social status certificate necessarily has the effect of depriving genuine scheduled castes and scheduled tribes or OBC candidate as enjoined in the constitution of the benefits conferred on them by the constitution. The genuine certificates are to be denied, the genuine candidates are to be denied admission to educational institutions or appointment to office or post under the state for want of social status certificate. The ineligible and spurious persons who falsely gain entry resort to dilatory tactics and create hurdle in completion of the inquiries by the scrutiny committee. It is true that the applications for admission of educational institutions are generally made by a parent, since on that date, many a time the student may be a minor. It is the parent or the guardian who may play fraud claiming false
Now
certificate.
kindly come to number 7,
My lord.
255.
In case the report is in favor of the candidate and found to be genuine and true, no further action need to be taken except where the
No,
report.
now therefore, why the action started?
Here, my lord, action started because of not getting certificate using false certificate by students in school admission. Now,
Understood, but who is going to do it? There's a reason why, na? Why, who is the person who can?
that
do
is
it?
why, my lord, that is why.
Can
in-
anybody come?
No, that is why, my lord, in Ayub Khan case, in the context of getting a certificate falsely or genuinely, my lord, Supreme Court has deprecated this practice of filing writ petitions or filing complaint by strangers, my lord. He was made out from the proceedings, my lord.
Because that is a very important thing.
Exactly, ma'am.
Because
Because
you
anybody and
cannot,
everybody.
because somebody has got, that is why 7 is very relevant. Why I'm saying so? Because 7 says that nothing is to be done once the report of vigilance comes in favor of the candidate. Means that somebody initiated the process.
Somebody has some others right as history influenced because of that certificate, my lord.
And not only that, this vigilance cell otherwise is not required to go into each and every case.
Exactly.
So it has to be on the basis of
A
some
complaint,
complaint somehow.
And complaint has to be by a person who is directly aggrieved, my lord, whose right has been infringed. In this Ayub Khan case, my lord,
Give me that.
yes, 2013 4 SCC 465.
Wait, give it to me. Wait, I'll take it out from here. 2013.
2013 4 SCC 465, my lord. Ayub Khan, Nur Khan Pathan versus State of Maharashtra. 2013 4 SCC, page 465. And making complaint by strangers, my lord, who has no interest in the issue, my lord, has been deprecated by Honorable Supreme Court. In this case, he was imposed with cost also, and he was kept away from the proceeding.
Now, another thing is that it would also may be a case of harassment.
Exactly, my lord. My lord will kindly appreciate this private respondent, my lord. He is, my lord, espousing the cause of Boros. He was one of the signatories to the government of Assam Accord in 1997-98, my lord. All along, he is representing the Rabha community, my lord. Just in the eve of the elections, my lord, I suppose the November, December elections will be held. After 30 years of his public life as Rabha person, my lord, this complaint has been made. And my lord,
No, that is the reason. Same type. It is the case of encouragement because of Mr. Dhawar's client.
my lord will also appreciate one thing, my lord. Petitioner claims-
Everything seems to be absolutely falling into the same pieces. That person also concerned was about to fight then the order comes.
Agree. And my lord will see, my lord, petitioner has claimed to be also a Rabha, but he has not annexed any certificate in his claim, my lord. My lord, may I read the judgment, my lord?
Yes, the paragraph.
Paragraph 1, my lord, just for the background facts, my lord. This appeal has been preferred against the impugned judgment and order dated 22/9/2009, passed by the High Court of Bombay, Aurangabad bench in Sandeep Monoharo Vaisal versus State of Maharashtra, filed by respondent number 5, challenging the caste certificate of the appellant. The facts and circumstances giving rise to this appeal are as follows. The competent authority in the present case issued a caste certificate dated so-and-so after following due procedure in favor of the appellant, stating that he does in fact belong to Bhil Thabi scheduled tribe. On the basis of the said certificate, appellant was appointed as senior clerk in Mumbai Corporation of Aurangabad, hereinafter referred to so-and-so, on 6/2/2019, against the vacancy reserved for person under scheduled tribe category. The corporation referred the caste certificate of the appellant for the purpose of verification the caste certificate scrutiny committee to the committee. The vigilance cell attached to the scrutiny committee upon conducting vigilance inquiry by order dated so-and-so found that the appellant did in fact belong to Bhil Thabi scheduled tribe, and thus the said certificate was verified. The scrutiny committee, on the basis of the said report and also other documents filed by the appellant in support of his case, issued a validity certificate dated so-and-so to the appellant belonging to Bhil Thabi scheduled tribes. After lapse of a period of 9 years, the respondent number 5 filed complaint dated 9/1/2009 through an advocate before the scrutiny committee for the purpose of recalling the said validity certificate on the ground that the appellant had obtained employment by way of a misrepresentation and that he does not actually belong to scheduled tribe category. In fact, the appellant professed the religion of Islam and therefore could not be a scheduled tribe. The scrutiny committee rejected the said application by order dated 13/3/2009, observing that it had no power to recall or review a caste validity certificate as there is no statutory provision that provides for the same. Aggrieved, the respondent challenged the order dated 13/3/2009 by filing writ petition number so-and-so before the High Court of Mumbai, Aurangabad bench, praying for quashing of order dated so-and-so and directing scrutiny committee to hold de novo inquiry with respect to the appellant's caste certificate. The appellant contested the said petition, denying all the allegations made by respondent 5 by its impugned judgment and order dated so-and-so. The High Court disposed of the said writ petition without going into the merit of the case. However, while doing so, the High Court set aside the order dated 13/3/2009 and remitted the matter to the scrutiny committee, directing it to hear all the parties concerned in accordance with the law as regard the allegations made by the respondent 5 in the complaint. It further directed committee to decide the said matter in a period of 6 months, hence the present appeal. Before proceeding further, it may also be pertinent to refer to certain subsequent developments. During the pendency of this appeal, this court, by order dated 2011/2009, granted a stay with respect to the operation of the aforementioned judgment, impugned judgment. By order dated 6/1/2012, the said interim order was modified. Honorable Apex Court may modified the interim order and extend to the extent that the scrutiny committee would re-examine the case on merit without being influenced by earlier proceedings before it and by giving adequate opportunity to the parties to lead evidence in support of their respective cases, after which the scrutiny committee would submit its report to the court within a period of 3 months. Then, my lord, the appearing for the appellant counsel, my lord, paragraph 6, raised a point, my lord, at next page, my lord, 475. Last part of the paragraph 6, my lord. It says, the action of respondent number 5 therefore completely malafide and indeed solely to harass the appellant, and the High Court committed grave error in not deciding the issue related to the locus standi of respondent number 5 in relation to him filing a complaint in the first place, as the said issue was specifically raised by the appellant. Therefore, the present appeal deserves to be allowed. Then, my lord, the counter argument is recorded thereafter, paragraph 9, my lord. Paragraph 9 says, It is a settled legal proposition that a stranger cannot be permitted to meddle in any proceedings unless he satisfies the authority court that he falls within the category of aggrieved persons. Only a person who has suffered or suffers from legal injury can challenge the act, action, order, etc. in a court of law. A writ petition under 220 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, or when there is a complaint by the appellant that there has been breach of statutory duty on the part of the authorities. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which writ jurisdiction is resorted to. The court can, of course, enforce the performance of a
No,
statutory.
no, understood. That is okay. Well, that is on the 226, I personally agree. My question is, who can initiate? Because you see, if you come down to paragraph number 39, which I was reading,
Yes, ma'am. Paragraph 39, ma'am. The correctness of the said judgment in Madhuri Patil was doubted and the matter was referred to and decided by a larger bench of this court in Dayaram versus Sudhir Batham, wherein while deciding the various issues involved, including the competence of this court to legislate in this regard, it was held as under the scrutiny committee is not an adjudicating authority like a court or tribunal, but an administrative body which verifies the facts, investigates into a specific claim, and ascertains whether the caste tribal status claim is correct or not. Having regard to the scheme of verification formulated by this court in Madhuri Patil, the scrutiny committee carry out verification of caste certificate issued without prior inquiry. For example, the caste certificate issued by Tehsildar or other officers of the Department of Revenue, Social Welfare, Tribal Welfare, without any inquiry or on the basis of self-affidavits about caste. If there were to be a legislation governing or regulating grant of caste certificate, and if caste certificate are issued after due and proper inquiry, such caste certificate will not call for
kindly
verification.
come. Thus, it is evident from the aforesaid judgment alone.
That the
But the-
purpose of issuing directions in Madhuri Patil was only to examine those cases where caste certificate had been issued without conducting any prior inquiry on the basis of self-affidavits regarding one caste alone, and that the said directions were not at all applicable where a legislation governing or regulating the grant of caste certificate exists, and where caste certificates are issued after due and proper inquiry. The caste certificate issued by holding proper inquiry in accordance with the duly prescribed procedure would not require any further verification by the scrutiny committee. Yes, my lord. That is why, my lord, in this case also, my lord, will kindly come to page, my lord. Paragraph 47, my lord.
Petition.
Same judgment, my lord, paragraph 47. That is why locus was important, my lord. Since Supreme Court has already allowed the committee to again re-verify, that's why this was passed. Otherwise, it would have been more stricter. The appeal is disposed of accordingly. However, considering the fact that respondent number 5 has not been pursuing the matter in a bona fide manner and has not raised any public interest, rather he abused the process of court only to harass the appellant, the respondent 5 is restrained from intervening in the matter any further and also from remaining a party to it. And he is also liable to pay cost to the tune of rupees 1 lakh within a period of 4 weeks. That's why. Here, my lord, since by an interim order, Honorable Apex Court directed the scrutiny committee to re-verify. That is why it was not halted. But respondent number 5 was also refraining from participating in the proceeding. This Madhuri Patil, my lord, was purely in the context of using certificates for school admission and government jobs, my lord. Now that has been expanded to the extent that, my lord, a person who is in the field of public life for last 30 years, as Rabha person, my lord, knowing very well to the petitioner, his certificate is now being attacked on the eve of the elections, my lord. So exactly ideal treatment should be, my lord, given to
But
this
what do
petitioner.
you do with the case in view of the judgment delivered by the single bench? And I think appeal is pending. But wherein it has held that this person concerned may be writing Soronia or whatever may be, they actually belong to this, they are not scheduled tribes.
Yes.
Now, there, I think the final exposition which came up by the single judge that all Soronias cannot, or but the Soronia community is not scheduled tribe.
Well, Sorania is a title, my lord.
It's a title being given of those persons who accept
Vaishnava
the Soron.
Vaishnava basically.
Yeah.
So that does not mean, my lord, anthropological that person becomes, my lord, a general caste.
No, not only general caste, that also anthropology doesn't mean that he is from the ST. That is also there. So under that circumstances,
My lord,
What he says in paragraph number 17, page 17 or page 16, is exactly that which has happened there. Now, if it is right, I'm not saying wrong, it's right. But if it is right, can he not initiate the proceedings, anything? Can you say that all this while this person concerned, the respondent number 5 was doing all these things? So under such circumstances, nothing is required to be done. Huh? Huh.
So once the evidence, they go for a pilot definition, they will go to door, they will pilot go to the background of the person, my lord. And they will pilot take whatever is their value. They'll go to the past, starting from land record school, certificates, everything, my lord.
So they are already proceeding. And there is already the process of issuance to the Vigilance Commission has already been done. If you see by the additional secretary to the government of SAM, page 21.
Yes.
So as they are already taking steps, we expect that it will be done in terms with Madhuri Patil.
Well, Madhuri, okay, so Madhuri
As
Patil-
per the directions of Madhuri Patil, read with the diagram and all.
Madhuri Patil also, my lord, accepts the situation that inquiries may not be possible at times to complete within 2 months. Ma'am. That's why it said.
It's
they will be
okay,
done.
but I
So-
would not fix a time
Because
limit
it is
that
not
is
there.
expected.
True, my lord. It is not his case, my lord, that inaction of the authorities, because of the inaction as per Madhuri Patil, he has come. It is not his case, my lord. He has parallelly gone to government and he is also invoking his 226, my lord. It's not his case, not his prayer that government is sitting over the issue, my lord. I will kindly see the
Mr.
prayer, my lord.
Heard, Mr. Your name? So and so the learned counsel appearing on behalf of the P.N. Goswami appears on behalf
That's number 5, my lord. General Counsel Rabha.
5. Ardhor appears on behalf of the numbers 1, taking into account the issue involved, taking into account the issues involved in the instant writ petition. This court takes up the instant writ petition for disposal at the motion stage. The petitioner herein claims to be a member of the Rabha community. The grievance of the petitioner primarily is as regards the extension given for a period of another 6 months to the Rabha Hasang Autonomous Council by the notification dated 6/8/2024. It is seen that the said exercise have been carried out in terms with Section 7(3) of the Rabha Hasang Autonomous Council Act 1995, which stipulates that the governor may, if he is satisfied that the circumstances exist which render the holding of the election as provided impracticable, extend the term for a period not exceeding 1 year. A further perusal of the said notification reveals that initially the period of the Rabha Autonomous Council ought to have expired on 12/2/2024, which was, however, extended for a period of 6 months by the notification dated 10/2/2024. Thereupon, by the communication or notification dated 6/8/2024, it had been again extended on the ground that the Assam State Election Commission by letter number SCC dot 26/2023/47 dated 29/6/2024 informed that some additional time would be required for completion of for holding the elections. Taking into account the reasons which is self-explicit in the notification dated 6/8/2024, it is the opinion of this court that the exercise of judicial review need not be, the opinion of this court that it is not a fit case for exercise of judicial review in respect to the notification dated 6/8/2024. It is further seen that the extension of the said this court, however, observes that taking into account section 7(3) of the Rabha Hassan Autonomous Council Act 1995, which mandates that the maximum period for which an extension can be given is 1 year. The petitioner herein would, however, be at liberty to approach if post this extension so given by the notification dated 6/8/2024, the elections are not held after the expiry of the extended 1 year. Next. This court further takes note of that the petitioner have also sought for a writ in the nature of tertiary mandamus, directing the respondent authorities to take action against the respondent number 4 by cancelling his caste certificate, which was produced by him to hold the post of executive member of the Rabha Hassan Autonomous Council, Dudnoi, Walpara, Assam. Also, it is seen that pursuant to the representation so submitted to the
Governor basically forwarded it, I suppose.
to the commissioner, to the respondent number 1, the chief secretary of the government of Assam, as well as to the governor of Assam, and as well as to the governor of Assam and the chief minister of Assam, a process have already been initiated, as could be seen from the communication dated 19th of June 2024 issued by the additional secretary to the government of Assam, Department of Tribal Affairs (Plain Dispur). Taking into account that proceedings have already been initiated on the basis of the said representation, this court would not like to issue any directions at this stage. Accordingly, would not like to issue a direction in this stage, which may issue any directions at this stage. This court, however, hopes and expects that the concerned respondent authorities shall bring the said proceedings to a logical conclusion within a time frame. We are keeping these matters open.
There are scheduled tribes, my lord, who uses title Das.
Scheduled tribes.
Scheduled tribe, my lord. They uses Das because Das means, my lord, these are all Vaishnavas, my lord. She converted to Vaishnavism, my lord. That and Madhuri Patil also says anthropological traits are to be decided, man. So anthropologically, they are to be.
They don't have that, no. They don't have.
I will not comment on that now.
You go on the various aspects. You have kept it is a different thing. Namesake is many things.
Deep level.
Item 8.
That relates to inaction of police for to investigate the matter. I have filed an FIR lordship that may be seen lordship case 14 against the FIR named accused persons lordship which was registered under section 4 of POCSO Act and 366 and 376 of the IPC lordship. Case 14.
According to
Yes, then
And they are not tried to even lordship arrest the prime accused lordship. And lordship prime accused and his family were constantly pressuring them along with the family was to settle the matter.
no, Mr. Kapil, what is this order annexure 3?
Actually, place of occurrence falls under the place of occurrence actually falls under the North Salmar, North Lakhimpur police station. But FIR was lost long before the Bangalmara outpost, which was under the Bihupuriya police station. Subsequently, matter was referred to the North Lakhimpur police station. IO of the case, Dada and IO of the case filed this petition before the court lordship to refer the case before the police station.
And why are you not approaching the that court under 156.3?
But 156 is now 175 BNS. That is after filing charge sheet.
No, this is 156.3 only because the incident happened on 20 prior to 1/7/2020.
Same matter, lordship.
Why you are not approaching?
156.3. That is after, so far my understanding from 156 lordship. That will come lordship after filing charge sheet.
Why? My goodness. 156.3 will come after the charge sheet.
non-registration of the affair. But lordships, from my personal knowledge, I can say that there is no such reference of any section is required. If we file an application before the CGM, he will direct the investigating officer to conduct the inquiry properly. Even he can
No,
approach
the law is very
SP.
clear by the judgment in Sakira Basu's case. Nothing doing. I would not entertain this paperwork. Go there. And how do you expect 1 month? They will do it. The concerned court.
Liberty may be granted lordship to approach.
The instant petition has been filed by the petitioner. Or Mr. So and so appearing on behalf of so and so. Has been filed by the petitioner, seek, writ in the nature of mandamus directing the respondent number conduct an effective investigation of the case in connection with Bipuria Police Station case number 50/2024, registered under section 366 of the Indian Penal Code, read with section 4. This court have duly taken into account the judgment of the Supreme Court in the case of State of UP versus Sakira Basu, reported in so and so. It was 2008 to SEC. Wherein the Supreme Court deprecated the manner of entertaining the petition, when the complainant can very well invoke the remedies under section 6(3) of the Code of Criminal Procedure 1972. Taking into account the above, this court is however, liberty is granted to the petitioner to approach the concerned jury under section 156 of the Code of Criminal Procedure if the petitioner is aggrieved with the manner in which the investigation
Nine.
what yes. Who is in possession of room number 45? Who is in possession of room number 45?
So, room number 45 was illegally given to private restaurant. Private restaurant.
It has already been allotted.
They married, but I have not taken about it. I was illegally allotted room number 5. But
Yeah,
in the law
understood.
says-
Your case is there was some lottery wherein you got 45, but by taking huge money, they have given room number 45 to so and so, and you have been given room number 5, and you were asked to deposit a particular amount, you have deposited under caution. That's your case.
I'm noticing.
We can only issue notice, nothing more than that.
Lordship, whether it is maintainable, Lordship.
Right.
The rooms are allotted by the Thekiazuli Municipal Board.
And
The
it's not a
lottery was
state.
conducted. A promise was made to him through that lottery that room number 45 will be allotted to him. That was not done. It was done to the private respondent number so and so. He was allotted another room. As a amount claim, the 40,000 rupees was paid by him. Now they are claiming 51,000 for 81. So is it not a civil dispute, Lordship, whether a mandamus can be issued regarding this type?
No. Mandamus is not on how much amount he has deposited. It is not his case. His case is the authorities in the lottery, he got 45 and thereupon he have 45 has been given to the private respondent and this amount the room number 5 has been asked to be given to him and against that he has deposited such.
Lordship.
His claim is not on the amount on which he says that this is an illegality. There is a procedure followed of lottery which have been violated. And this violation is by the state authorities.
Not by this, it's a municipal board, Lordship, it's not, I think it's not a Thekiazuli Municipal Board, Lordship, it's not a state, Lordship. Guwahati Municipal Corporation, Lordship, it's a state.
Municipal
Thekiazuli,
board is not a state.
Lordship, whether it is run by.
Occasionally would become under the Assam Municipal Act. Then
But Lordship, they have unnecessarily, they have made this deputy commissioner.
why are you
circular,
making
they-
this deputy commissioner and circle officer party?
Yes, Lordship.
Fifty comes otherwise in my lord. Falls under section.
He has no business. We strike off 4 and 6. Okay. And you file a fresh memo parties also. Fresh memo parties, we strike off 4 and 6. Issue notice returnable on 18th of September 2024. Third,
I am for 1 and 2, 3 lots.
1 and 3. Urban development is
Padma Nayak Lordship, I have been told.
1 and 3. I shall my appeals to respond number. Who's to, there's also been submitted that Department of Urban Development, the government of Assam has a standing council who is Mr. Nayak. This court also finds it relevant to take note of that the issue involved in the instant proceedings has no relation as regards the respondent number 4 and 6. And they have been unnecessarily arrayed as a party.
Maybe because he's also the executive officer of the board.
Oh, executive officer. It is under suspend dissolution. Is the board under dissolution? When it becomes a dissolution, that's a different thing. This is not done by executive officer.
Done by the board, my lord. Board is.
Anyway, take your in the, yeah. What is? Mr. So-and-so appears on behalf of respondent 1,
And 6.
4 and 6.
Lots.
2A2,
Nayak.
taking into account the above, this court, taking into account that the respondent numbers 1, 3, 4, 5, and 6 are duly represented by Mr. H. Sharma, served upon him by 16/8/2020. As regards the respondent number 2, the petitioner is directed to take steps upon the standing council of the Urban Development Department and serve him an extra copy. Insofar as the respondent number 7, the petitioner is directed to take steps by way of registered as well as usual on or before 16/8/2024. You want an early disposal? You want an early disposal?
Yes, sir.
The petitioner further is given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. It is the case of the petitioner herein is that the petitioner pursuant to an allotment, pursuant to a lottery, pursuant to a process followed by the Thekiazuli Municipal Board for allotment of rooms in Rabindra Bhavan ground floor, Rabindra Bhavan. The petitioner was to be allotted room number 45 as per the lottery draw, which was held on 3/1/2017. However, the respondent authority, however, it has been alleged by the petitioner that the respondent number 5 have for reasons other than bona fide, have allotted the said room in favor of the private respondent number 7. And the petitioner have been forced to take room number 5 against his wishes. It is also alleged that the petitioner under such compulsion had also deposited an amount of rupees 51,480
It's rent. It's rent.
Huh?
Rent.
rent. No. My share legal action allotting me so and so and depositing and to deposit so and so. It deposited 51,480.
Yes.
The respondents shall on the returnable date, the respondents, more particularly the respondent numbers 5 and 7 on their returnable date shall bring on record their stand by filing the affidavits.
Number 10.
Lordship is making it returnable by 4 weeks.
Date I have given it. I have only asked the respondent number 5 and 7 to file. Yes, what is this?
In order, my lord, 18/1/2024, my lord, lecture 8, my lord, page 59, my lord. Wherein, my lord, the respondent number 4,
Withdraw.
my lord,
Withdraw and file 227. No business of 226.
the
How are you filing 226 against an order?
something that I disclosed, my lord.
What?
One important thing, my lord, the impine order passed by the land as special tribunal in Rabha, my lord, against which, my lord, the appeal filed.
Understood. That is why I'm asking you to file 227. You can't file 226. You have
Already
brought
your
the
lordship-
certified copy? No.
My lord, your lordship can convert it to Article 227, my lord.
Am I? How?
So there's ample reason.
What business does the state of Assam has in the proceedings in land grabbing? What business does the deputy commissioner has in a proceedings in a land grabbing? What does the district and session judge has in the process of land grabbing? Only person who has to be made a party out here is this Bonti Hazarika Bora, who's has here. So how do I convert it? And what is this business of making a judicial officer a party?
Not by name, my lord, by my designation,
What?
not by name, my lord.
Forget about the name. How are you making a court a party?
My lord, then,
I
liberty.
can do only one thing, dismiss with costs on and deprecate the manner in which it is being done. What do you want? Withdraw or dismiss?
No, my lord, withdraw.
Withdraw.
Withdraw the
Fantastic.
liberty, my lord.
Mr. T.U. Law Scholar, the learned counsel appearing on behalf of the petitioner submits the petition and file an application under Article 2 to 7 of the Constitution challenging the order detail
18/1/2024, my lord. That annexure
dated 18/1/2024 passed by the Special Judge, Special Tribunal Nagaon in Mizze case number 9/23 arising out of Special LG case number 15/2021. Taking into account the above, the instance closed on withdrawal, however, liberty is given to the petitioner. File appropriate application, file application under article as per the appropriate provisions of law.
fully obliged.
It's an injunction order. And how do you do? You can come under 227.
Like-
Yes, who is this, Mr. I. Chaudhary? Times have to always tell, you can't file writ against judicial of. Yes, what is this? You are challenging 2/3/2023.
Yes, my lord.
What is this?
My lord, here, my lord, as per this communication, my lord, even the private person who is going to construct building, my lord, is required to pay.
Oh, that one, same order. There's some order. My order is there. Where is my order?
The lordship has passed the order last week or the,
Where is that?
my lord, I have to annex a different order.
Hey, to order did you? To sign my order. Stays there, na?
Yes.
We have to fix a date, but this court has fixed a date or not, I don't know. No, yet date is fixed. Yes, who is appearing for GMC? This is done by GMC, na? This action is by the GMC in giving promotion. This is, you want to make a private building.
I am going to make a private building, but I am made to, if because of this.
Made it here. You can't, you have to, when are those matters fixed? We need to finish up this thing.
For 4 weeks. It is being led by 2040/2023.
Which
The
one?
leading case. The leading case, lordship, 2040/2023. It is,
2040 of 2023.
23, lordship.
We get it listed. Next week, we finish it off.
Uh,
Unnecessary, this type of litigation should not be there. Because the GMC has no business out there. You can do that. You have filed your affidavits.
Lordship, I have been informed that our draft policy is being prepared by the government, lordship, which is why
Draft?
a policy decision is being prepared by the government, lordship.
So, policy,
Why
then
some
again,
time will be-
Mr. I. Chaudhary will challenge. Give him an opportunity then also. You cannot stop the lawyers to come, no? You'll have to have something. We finish up this, then he has to come another. Would not like to be stagnant in one matter. The same order, issue notice making it returnable on 23rd of September 2024. বাকি খিনি অর্ডারবোৰ সব এখিনি number 10 টোত list accordingly হ'ব। Accordingly on so and so, list accordingly as directed above along with WPC number
2023.
Well,
এনেকুৱা বহুত order আছে। See clear. Yes, what is this?
Yeah, the petitioner is businessman, lordship. He purchased one JCB, lordship, on the term loan sanctioned by the respondent bank authority, lordship, of 20 lakhs, lordship. Thereafter, lordship, he gave the said JCB on the basis of hire to one parcel of Mamit district, lordship, Mizoram, lordship. So the said vehicle was missing, lordship, on 26/4/2022 to 5/5/2022, lordship. File an FIR before the concerned lordship, Mamit district, lordship. So after investigation, lordship, the police returned that there is a FR lordship, there is no chance of recover the said concerned vehicle lordship. So lordship, the bank authority also wrote a letter to the SP of the Mami district lordship. So whether the information regarding the FIR number 44 dated 22/8/2022 lordship. The concerned police district lordship informed the bank authority lordship kindly see page 33 lordship,
Page?
page 33 lordship.
No, you are challenging which order? 14-6.
Yes, I'm telling the, I'm just saying about the fact of the case lordship. So thereafter, when the vehicle was not found lordship and the police was given the effort that there is no chance of recover the said vehicle lordship, JCB lordship. So I have informed the missing of my vehicle to the insurance authorities, also the bank lordship. But the bank authorities department lordship, they file an OA application before the DRT lordship for recovering their outstanding amount of loan lordship. So after receiving this summon lordship, notice lordship, I appeared to the Thane council lordship. So here it is some time for giving the WS lordship, written statement come on evidence lordship. But due to some miscommunication between the petitioner and the council lordship, the petitioner is unable to file the WS come evidence lordship.
Why?
In the concerned date lordship.
Why?
So there's some miscommunication. The month of May lordship, there is some flood situation in Kachar district lordship and the
Flood?
flood, yes,
Where?
Kachar district lordship.
Where?
The month of May lordship.
Where is the flood?
I have written lordship in my paragraph.
Where is the flood?
Flood,
Silchar. Flood. Show me.
month of May lordship.
May, the entire month. You were given 2 dates, 2/5 and 15/5. And the order was passed on 16/6. So from the month of May, all this time, you have not filed your affidavit. You appeared on 2/4/2024.
So
You were asked to file. Why should this court at all entertain this type of dispute? You don't file. This court cannot open the floodgates.
In any case, no, there is a remedy of appeal in section 20 of the RTP Act.
Where?
The DRA people cover. All orders passed by the DRT under that.
Understood, but for this thing, you have to go there. You pay the expenses for that. You will go there.
But the-
No.
depending on the-
Now, are these DRAT done through online mode?
I'm not aware of this, but I think.
Is
process
e-filing done?
Now the process is starting. E-filing is done. E-filing is started here also in DRT, Guwahati also. But as far as the
DRAT?
DRT e-filing is done regarding the hearing, alert, I'm not aware of that. But I think it's in the way, it's in process. It will be started if it's not already started. I'm not aware of DRT, but I think it is in the process. It will be done. But in this case,
No, for this court to interfere, more particularly under 226 does not arise.
there is also a judgment of the Supreme Court, SBI versus Allied Chemicals, in which order of the final order of the DRT was challenged in the High Court under Article 226. Supreme Court will set aside the order of the High Court. That judgment was-
While under 227,
227, he may have a remedy, but when the appeal remedy is there, my lord, when whether.
we actually ought to approach under 227, not 226.
I mean,
226, you cannot
no,
come.
The DRT itself had number of judgments in the Supreme Court, the DRT did not extend the time. The time for filing WS and evidence is 30 days. At the most, my lord, 30 plus 15, 45 days, and that too for reasons which are to be recorded in writing, exceptional circumstances. So even the DRT has no power. He'd be acting beyond his jurisdiction.
Exceptional. Let us see that provision.
ITPL, recovery of debts.
Has this provision of 19.5 been dealt with by any judgment?
Specifically challenged or not, not sure, but it came in 2016. Then it has, I think it effect on 1/9/2016. RDB Act was amended, and after that it has been, that has been the norm. Like there are certain judgments which have held that the BRT doesn't have that power.
So earlier it was, could have been given, but now in the similar interpretation which is being given out there to the
Because-
Commercial Courts Act would apply.
Yes, and also the Consumer Act, CPA, that Hilly multi-purpose case. Supreme Court specifically held that if the time limit is set, then the consumer forum cannot go.
No, there is another judgment in top line.
There are certain other, not very detailed judgments, but short orders. So one, if I may recall, I think it's Justice Gawai, which he has dealt with this aspect of the matter, that the act itself provides a specific time limit. There is, the BRT cannot go beyond that. Of course, a constitutional court may, we can try under 227. But the BRT certainly cannot.
Where the appellate, yeah,
Section 20.
section?
20.
There are two things, Mr. Ganguly. First, whether 226 can be at all exercised. If it cannot be exercised, then I'll have to ask him to withdraw and file 227. If it can be exercised, I can go and dismiss it, holding that this cannot be given. Or what do you mean? Or he has the right of filing an appeal in terms with section 23. But the moment I say that the 226 cannot be entertained, then I cannot go into all these things.
It will be up to him to go under 227 or file an appeal as well. Because your lordship states in the order with utmost humility 227. He will have that remedy under
So
227.
against the DRT, writ won't lie.
It won't lie. Like there is one judgment of the Supreme Court lordship. Have it on Friday, perhaps I'll place.
I'll have it on Friday.
I'll place all the letter. He may give me a copy of the petition.
We have not given.
This matter, appearing in telephonic instructions.
Okay, give him a copy. Huh? Mr. A. Ganguly, the learned council, the standing council of the Punjab and National
No, I'm not sending it. This is Bank of India.
Punjab, Mr. A. Ganguly, the learned council, submits that he have been instructed by the response Bank of India to appear before this court in the matter. A copy of the writ petition be served upon him during the course of the day. List the matter again on 16/8/2020. That is the only thing, because the moment I exercise 226, I can then say
I'll
that
bring
it
the-
cannot be. You
I'll bring the
cannot
relevant
extend.
evidence.
But
Yes,
if I don't exercise, then you may be. Only thing is, he has to withdraw and avail other remedies. I won't say 227 also, because saying 227 may also, this court is giving him the liberty. That matter? Yes, tell me.
Was made in while purchase itself, so the application is not available. Exercise. But the
Isn't it the mandate of section 50 Section 50 of the Assam Land and Revenue Regulation that you are to make the application within 6 months.
Was made and a order was passed.
Where?
That is Annexure 5,
Next year?
Five.
Page
page 59.
59. Then
Thereafter,
nothing has happened. Then
so then again, he made an application on retirement, that is in 2016,
where?
to the commissioner, that is on 1st/6/2016, Annexure 9, and page number 71.
What did he say? Then, but where is your application? You did not make any reference that you have your application.
Application, and through that application, this order was passed, that they will be resettling, they will be giving the mutation at the time of resettlement operation. And that was.
Understood. Did you approach the settlement officer? Where?
First it was the settlement officer.
Yes. You should have gone to the settlement officer, show him that look here, this is the land I purchased, 53A. There's a provision. Have you approached?
Was filed to the deputy commissioner there, because at that time the settlement was closed. And thereafter, the settlement officer's role was all transferred to the deputy.
So where is your application?
Number,
You don't mention anything, a single word out here that you submitted your application which is pending. You say that I have not filed an application. See? I have not yet obtained mutation order for purchase or but in possession of it. This is your line, page 71.
Page 71, but here, page 72, it says that the land properly purchased and possessed by undersigned should be rectified and necessary concerning revenue records may also kindly be corrected and.
You
mutation may
cannot
be granted.
seek for correction in this manner. You have to file an application for mutation.
File the application, my lord.
Where?
The annexure 5 was the.
Annexure 5 is you submitted this, they say that then why didn't you come up that this is your application number? Where is it that you have informed?
Time, the photostat machines and things were not there. So therefore, if whatever format was there, he just filed it.
Your land was taken over, that entire block of land, which originally belonged to PG Dombrain, and thereafter was, of which I think 10 bighas of land or
Were not.
22 bighas.
Uh,
And was gifted
West.
to Brahma Chaudhary. He got his name mutated in that particular dag. Thereafter, he sold many lands,
that-
of which
we
one
should come for say that.
you purchased from second or third seller from there.
He had the purchase.
You purchased from whom?
This land from Kapote, and he himself, Kamal Chandra Kapote, and he obtained it with mutation.
And Kamal Chandra Kakoti purchased from whom?
Chandra Kapote purchased from this whole line is there. My lord, I can just read it out. when Komal Chandra Kakoti purchased it, plot I bought from Satyajit Goyal. And he had purchased from this Brahmananda Chaudhary. And then Kamal Kanta Pathak actually. And he had also purchased from Brahmananda Chaudhary. And from thereafter, we purchased it and it was all mutated. All along, it has been a Niyadi Patan. And that's in para 6, para 5, 6, and 7. Seven is the annexa for annexa 5. 7 is the paragraph for annexa 5.
Do you have any quarrel with this person, Haruna Rashid?
No, our neighbor. I mean, he's also sold out, but we have no quarrel. In fact, we have attached his mutation as well. Aruna Rasid also bought from Brahmananda Chaudhary and we have attached his mutation in Annexa 13, A and B.
Now what do you want?
His 5 bighas. So from Kesavananda,
Haruna Rashid has purchased 10 bighas.
somehow we have obtained.
Two
a
sale
purchase.
deeds. One is in the year 73 and another is 75. That is why I'm asking you.
So we have annexed.
What do you want now?
13 A and B, we have annexed step for sort of
Directing here to
Yes.
mutation and but you have not filed. I don't file anything.
file. And that is
No,
why
no,
we
you
got
cannot.
this
You
order.
have given me a number.
Resettlement, this Annexa 5 is vital, my lord. Annexa 5 is vital in this. They have promised us that they will be giving us the mutation in the resettlement. They have made an error. And all
There
the-
is a communication issued by the settlement officer, which by the circle officer, which I can see.
Yes, the
Where
circle
is it?
officer also has written a number of letters and the deputy secretary has also done a great help because he is saying how it can be
No,
done.
the deputy secretary has done a great help. Go there. Yeah,
Despite that, the deputy commissioner didn't.
but
do
I
it.
don't find
That's
that
my case.
application. Where is your application? Where is the problem arises?
Done in a proper format.
Yes, what do you say? The problem arises here. No application.
Giving any application, you cannot forfeit.
No, now the land has been shown as government land. That
Huh?
was
Shown. Even we were paying tax until 6/6/2016. Now it has been shown incorrectly after this, definitely that 37.
how are you paying? Your mutation was only in respect of 2 kathas of land.
For 2 kathas of
The-
land.
2 katha is okay, but that 2 katha is not the problem.
That is also a problem because that is also shown in the government, but Sarkari Dag now.
Where is your statement to that effect?
Statement to that effect that is.
Because why you look at your prayers at page 39. Correct the relevant records of the land measuring 2 kathas covered by so and so and so and so are rich in the nature of AR. Directed to rectify the mistake and above and shown in the Sarkari.
Pair 1 and 2, my lord.
Okay, we do one thing. We issue a notice. Let us see what.
I was an authority in this and we are seeking your guidance in this. Because you know this area so well, we are seeking your guidance. in
But
this.
it has now been shown as Sarkari.
All the this near the Pata land is now shown as Sarkari by mistake. That's an error.
Or issue notice making it return.
Not
Go ahead.
picture 33 last page, madam. There is a notice, madam.
Nature
Last page, 162, page number 1.
notice is hereby issued to consultate. Relevant report in the original hearing on the. Yes, what happened here?
happened to this, and I admit to one mistake of mine. I should have written a little more in the last paragraph also pertaining to that. As in, paragraph number 32, but nothing happened. They have appeared, the successor has appeared, but I should have added another 2 sentences. I admit to my mistake. This is a council's mistake. So,
Understood, what has happened here?
he went, the son,
Then what happened?
and he also made an
But
application.
nothing
That
happened.
is-
There's the proceedings being taken over by the, he's asked to instruct the concerned manor to be present along with Rebina on the date of hearing.
he was
What happened
present.
to the hearing on 4/4?
Went and he was present there, but there was no outcome of it.
So there must be another date given.
Nothing else. No dates given, nothing. And
Oh,
that's what I should have written.
Making it returnable on 20 khula ase na? 29, 2020. Mr. Miss P.R. Mohanto appears on behalf of the and 4. The J.C. Hendrick appears on this file to respond. Respondents have duly represented extra copies of the petition listed by 16/8/2024. Case of the petitioner here had purchased separately 2 plots of land in the same Dag and Patta number at measuring 2 katha and 1 katha 10 lechas. The land measuring 2 katha was stated in the record of. However, on the land measuring 1 katha 10 lecha was yet to be. In the case of the petitioner, that the petitioners have been paying land revenue, kathas of land, and were also pursuing as regards the 1 katha 10 of lechas of land be muted. However, to the shock and surprise of the petitioner, that 3 katha 10 land has been shown as Safari. Also seen from that from the enclosures to the that a notice was issued to the petitioner, Additional District Commissioner Kamruk Metro,
Following his application.
that a notice was issued to Commissioner Kamruk Metro to the petition to the predecessor in interest of the petitioners. 6/3/2000. Son is who?
Three. The son is the
Number 3, duly when he had participated in this, thereafter nothing has happened. It is under such circumstances the petitioner has a direction of seeking the various reliefs. How the land of the petitioner was duly a patta land. How the land of the petitioner has been shown as spite of the fact that kathas of land have been duly mutated in the name of the petitioner. And 1 katha 10 lecha, the mutation application has been pending. Further, at private court, further action is taken in pursuance to the and the hearing which was conducted on 4/4/2024 as is Section 43 to the
Much obliged. Much obliged.
In persons to the work order, my lord, I have executed the order, my lord, that was not acted upon. Then, my lord, it subjected a reexecution. Thereafter, my lord, in persons to the order of the honorable court, payment was made to me. My lord.
You got the money?
Thereafter, my lord, they asked me, my lord, at page 46. My lord, 60 lakhs. Accordingly, my lord, I have deposited that, my lord, they said, my lord, they,
Why 60 lakhs?
my lord, they said
40?
the excess money, page 46, BC.
Avoidable expenditure may understand. Cover 60 lakhs. Then,
But I asked back the money, my lord, but that has not been acted upon. My lord. Page 52, my lord. That effect, my lord, no affidavit, nothing has been filed.
yes, why no affidavit? This is Mr. Ardhor's department.
Still welfare department.
Ah, now, this social welfare is no longer there or there. Yeah.
Someone designated their name.
What are the name?
My lord, social justice or something like that.
Who is paying for social justice?
I have to check, my lord, some of the methods we are appearing and some methods are dust, RC does.
Are he does.
So
Another one, social justice. I think Mr. Ardhor is there.
Ardhor, my lord, no, my lord. No.
Why did you pay the 60 lakhs?
My lord, they asked me, my lord, otherwise, they said, my lord, they will refund it. Otherwise, my lord,
Where is this paid that it will be refunded? Tell me.
they said verbally, my lord. And
No,
I
no,
said,
verbally cannot be the ground. You
Can-
see,
shall we see the
no, no, if the communication see, with reference to the fact, I would like to inform you that the Accountant General had made observation in para number so and so, observation extra avoidable expenditure of under so and so and so and so. You are hereby directed to recover excess payment
They said,
of so and so. Now, who said to you that verbally?
they said,
Make
my
him
lord,
a party. Have you made him a party?
social
verbally
welfare
say?
department is a party.
Huh?
The party.
Who?
Is the director, my lord.
No, make him a party by name. He has verbally given you some assurance. When on the other hand, this document categorically says that this is an excess amount.
My lord, excess amount, my lord, accountant general cannot give, my lord. After making payment, that too on persons to the order of the honorable high court. They did not make payment. Honorable court, my lord,
Whatever may be, why did you pay? You should have challenged this document then. You paid it, no writ, dismiss. How can a writ be issued out there? You paid on your own.
my lord, I am a contractor, my lord. I
So
don't
what?
want to-
This is recovery of excess payment. You should have challenged this. Who asked you to pay? There must be some good reason. This court is not entertaining this type of it. Or
That-
Mr.
that
JL.
File affidavit, my lord.
No, nothing is. No affidavit is required in this type of matters.
My lord, lordship kindly see page
No,
52. my
No,
lord. That
nothing. Mr. JL moving appears on behalf. None appears on behalf of the responsible Mr. None appears on, who is Accountant General? Mr. Ardhar, do you appear for the Social Welfare Department? Yes, yes. Now come here. See the file. This is very relevant because I remember these are all these Cottonians. You see, here, kindly come to Annexure 6. Okay. Here, there was a direction given by the Director of Social Welfare that in view of the objections put by the Accountant General of Audit, because this is an audit objection. directing them to pay this amount of rupees 60 lakhs and another 20 lakhs, which comes to around 86 lakhs. In pursuance to that, without protest or without challenging to that, the petitioner paid. Now, after making payment, he then submits a representation on 31/10/2022, Annexure 9, that kindly refund that amount. On the ground that you inform us to pay. This is not you inform us to as per your instruction. It was categorically said to be as an excess payment. So if that be so, either it will be a case of disputed questions of facts, or at best, it would be a case where you are paying this cotton, this thing, nothing doing. This is a case for sure or dismissal. Which one do you want?
Can it be like this, my lord, after tomorrow, my lord,
No.
I'll take instruction, my lord, we,
No.
if they
Don't
proceed,
withdraw. Withdraw, you are finished. Should I dismiss it on the ground that you cannot? Or should I dismiss it on the ground of disputed questions of facts? You tell me that. And that you don't need instructions. Dismissal is mandated. There is no quarrel. But how it is going to happen? I'm giving you
lordship,
that.
give me, my lord, 1 day time. my lord.
No, dismissal is, no, there's no quarrel that it is being dismissed. But the question is, you want a dismissal saying that you are not entitled, or saying that this is a question of disputed? I said that liberty is given to you to approach the appropriate authority, approach the civil court if so petition. Which one? You want to end everything here or here? We can do it by 2 o'clock.
My lord,
2 o'clock. Dismiss too, there's no quarrel.
can it be like this, my lord? I'll withdraw it, my lord, and will approach to the civil court.
No, you cannot withdraw. I'll have to hold that I'm dismissing it on the ground of limited, that this court cannot decide on these disputed questions and entertain. And as such, I'm dismissing you and thereby giving you the liberty. Kindly appreciate that. If you withdraw, you don't get the benefit under Section 12.
At 2 o'clock.
Yes. Now, I'm only asking you which one.
Or, my lord, they have raised any, whether this amount they are going to refund or not, my lord.
No, on the face of it, this document is clear.
It's true, my lord, they have
You have not challenged this document.
before deposit.
You have not challenged this document.
Instant case, I have challenged. Instant case, lordship, kindly have a look the prayer, my lord. I challenge this document.
Oh, no. After depositing, there's a waiver.
Yes, after depositing,
Then it is you have waiver.
after depositing, I have challenged. it. Prayer number 1, my lord. A, case 22.
Nothing. Chalo, let me dismiss it.
But anyway, my lord, my way to be kept open for approaching to the civil.
No, if I dismiss it, then there is nothing. I dismiss it on the ground of any other aspect, because the moment I touch this document, 2nd of June, the moment I touch this, your case is gone.
Then with the liberty to approach the civil. That may be.
The jail board here, the learned counsel appearing on behalf submits that as to whether the petitioner had paid the amount of rupees 60 lakhs 68,000 under duress and caution of the respondent authorities is a question of fact which can only be established by way of proceedings wherein evidence can be adduced. He therefore submits that he may be permitted to withdraw the instant petition. However, he also submits that the withdrawal of the instant writ petition should not prejudice the petitioner to avail remedies by way of filing a civil suit. Taking into account the above aspect, this court closes the instant writ petition on withdrawal. However, liberty is given to the petitioner to approach the civil court. He is aggrieved. Approach the civil court, claiming the said amount. Yes, government? Any instructions?
Item number 16, I have received one, para was from long back, 23 mein hai, but 16. This is 15 and 16 are similar.
16 નું માં તો કે કેલે. None appears on behalf of the petitioner on call. Both the petitions in the writ petitions raises similar disputes as regards acquisition of the land of the petitioners, as regards apprehension that the lands of the petitioners would be acquired, would be taken, alleging that and apprehending that the lands of the petitioners would be taken away without following the due process. This court, while ordered it as 7/2/2023 in both the writ petitions, directed the respondent authorities to not to take any steps for eviction of the petitioners from their land. Today, Mr. J. Hendig, the learned counsel appearing on behalf of the district administration, had submitted that in respect to the land belonging to the petitioner in WPC number 670/2023, eight lessors of land in dark number 272 and one lessor of land in dark number 271 have been demarcated, which falls under the railway route which was left out from the acquisition process undertaken during 2011-12. Under such circumstances, certain steps have been taken for initiating an acquisition proceedings for acquisition of the land in question. And the process for acquisition of the land of the petitioner is now undergoing. The said instruction is, however, dated 1/6/2023, which is a year back, and do not state anything as regards the land belonging to the petitioner in WPC number 669/2023. Under such circumstances, this court fixes the matter again on 31/8/2024, on which date Mr. J.C. Hendricks shall obtain necessary instructions as regards the land, as regards the acquisition process to initiate it, and as to whether any portion of the land of the petitioner in WPC number 669/2023 is being taken up for acquisition. List accordingly. The instruction so this is kept on record and marked with the letter X, X at all.
Well, this matter has now become infructuous. The matter has now become infructuous. Malad, the petitioner was the erstwhile president of a Gaon Panchayat.
Has become infructuous.
Infructuous, Malad. The president had actually
Mr.
challenged.
P. Bodley, Hendik, PNRD, appearing on behalf of the Panchayat and Rural Development Department, had submitted that the writ petition has become infructuous, taking into account that the petitioner
The petitioner had challenged the outcome of the no confidence motion, Malad, by which he was removed. But in the month of February 2024, the entire tenure of the panchayat had lapsed, Malad.
that had become infructuous in view of the fact that the petitioner herein have challenged the no confidence motion by which the petitioner was removed. And in the year, and when did the entire tenure expire?
Malad, February 2024.
And in
Lapsed.
the month of February 2024, the entire tenure of the panchayat,
Panchayats.
which panchayat?
Gaon Panchayat, Anchalik, Zilla, all the panchayats were dissolved.
The tenure of the various, what is this? Which panchayat is this?
This is Malad, Duluhat Sonapur Gaon Panchayat.
Of the Gaon panchayat in question have already expired.
Lakhimpur district.
Full stop. It is also seen that the petitioner is not represented today. Taking into account the above, it is seen that the petitioner have lost interest in the matter in view of the fact that the writ petition has become infructuous. Accordingly, the instant writ petition stands dismissed as infructuous. Interim orders, if any, stands vacated. Yes,
I am for the private respondent.
fantastic. Yes, what is this? What? Husband is presently undergoing a sentence passed against him under NDPS Act,
Yes, my lord.
and the present notice
Appeal
has
of-
thus been served on her. Petitioner, who is this wife, apprehends that the property exclusively belonging would be forfeited.
My lord, appeal also dismissed, appeal also, criminal appeal also dismissed by this honorable court. Now regarding forfeiture of the property in the NDPS Act under 68H, notice was issued. And wife came before the court he saying that this property is her property. So only notice issued, my lord, she has to go there and appear.
Where? Which notice?
Notice, my lord, memo, when a page 36, 26.
Page? Who is the petitioner?
Petitioner is Ranu Das. Wife of the person who was arrested, who was in behind the bar. The notice was issued on
Whose property is this? House number 10?
notice was issued in the name of the accused person, Deepak Das.
But have you included this property within the ambit of your notice?
Well, actually, regarding the rest number 2, this is an independent body, I am actually formal for only for revenue department. Regarding rest number 2, my lord,
There, you were very upright out there and making various submissions to dismiss his petition. But I'm asking you, on one hand, the description of the property has been mentioned as house number 10, Jyotipod, Janakpur, Kahilipara.
yes, yes.
And if you see the sale deed, one katha of land covered by Dag number so-and-so under so-and-so in the district of so-and-so. Then notice has been issued.
But stay was not granted, but what is the further outcome of the notice, my lord, that instruction has to be shown. Otherwise, my lord,
No, the question is, can you forfeit anybody else's property?
no, that can.
But madam, why are you not showing it to the authorities that this is your property? Why should this court interfere? There is a procedure. Go there. You have a good ground board. You show that. And that too, you have challenged it when? 2023, a notice of 2015.
15.
Yes. You cannot do that. Leho. Your name? So and so appears on behalf of the petitioner. Mr. K.K. Parasar. Appears on behalf of the respondent number
Left one.
one.
Revenue.
Who appears for two?
To my lord, this authority, my lord, yes, under the income tax, my lord, but
Huh?
yes, my lord, I can appeal.
You can?
Under the Ministry of Income Tax.
You are appearing. There's a notice of 2022. Where is that? What have you done? There's no stay given here. What happened? What?
Point, the ma'am has
Withdraw.
no pass over the matter.
No, passover doesn't happen in this court so easily. This is the most toughest thing. To get a case decided in your favor is easier to get a passover. Tell me. Can't get a passover. What happened here? The petitioner herein have assailed a notice dated 14/10/2022 on the ground that the respondent authorities are trying to take over, confiscate, forfeit, nah?
Yes, my lord.
Forfeit the property belonging to the petitioner, although the belonging to the petitioner, which is the personal property of the petitioner. And as such, the proceedings under section 68, na,
68 H, capital H, my lord,
of the
NDPS.
NDPS Act 1985 could not have been invoked insofar as regards the property of the petitioner. In that regard, a sale deed had been enclosed to show that the property so mentioned in the schedule to the notice dated 30/12/2015 is the property belonging to the petitioner. This court, however, takes note of that by an order dated 15/2023, notice was issued and there was no stay to the said proceedings. Neither the petitioner nor the counsel appearing on behalf of the respondent is aware of the fate of the proceedings so initiated by the communication dated 14/10/2022. List the matter again on 31st of August 2024, on which date Mr. K.K. Parasar shall apprise this court as regards the outcome of the notice dated 14/10/2022.
Can it be, my lord, first week of May, my lord?
No, 31st. 31st is given open, so it's a free day for me.
I'll be out of station, my lord.
Don't be out of
For
station.
medical.
Get a hold of anybody else. Ask him. He's also a central government council. Get your instructions.
If possible, my lord.
No possible. These matters are to be fixed. I found it. Okay. Hey, retake the second.
Second.
If the 19 lordships, I need some time, lordship.
Why?
Last occasion, lordship, I was.
What is this matter about? You need time in these matters.
Allotment of government land.
Take necessary steps for completing the process of allotment of the land measuring 1 biga 3 katha so and so under so and so. So in terms of Iman, by the Deputy Commissioner Iman. Yes, what is this?
My prayer for allotment of the government land by the Land Advisory Committee in 2011. Then it was forwarded by the then District Commissioner to the Revenue Department. And
communication between revenue and district commissioner, my lord, that is there, and till 2017, I have the letters. Because what has happened is that after 2017, the joint secretary, revenue has addressed a letter to the district commissioner seeking some clarification. That,
Huh?
some clarification, Lord. Page 48. Page 49, actually.
It request to clarify whether the those settlement. But they have asked the deputy commissioner.
Because the deputy commissioner in the letter at page 48, you know, that is the forwarding letter. He has
They
said
file an affidavit in opposition.
Yes.
What do they say?
revenue is filed, my lord. And they have
Nothing
agreed
has
with
on
the-
demand actually found to be recommended in the name and the land for allotment using the avatar was it in seeking clarification into. Who is reviewing for the revenue? Yes, what is this? This is what land? What is this land?
Lordship, we have written a letter to the deputy commissioner regarding the clarification, settlement and allotment.
My goodness.
Lordship, may peruse the,
No, you have a land policy of 2019. What is your land policy? It says that first you will go out and grant an allotment for 3 years. And after the allotment, you see that he is still possessing, he is doing as per what it is, then you'll grant him the settlement. Isn't that the land
And
policy?
that is reflected.
Then why are you spending time in unnecessary communications? These are absolutely environment degradation by writing all these papers. To dispose it of, directing you to take a word. If he is entitled to the allotment, give him the allotment immediately, and that will follow. And thereafter, within 3 years, if he is satisfactory, give him the settlement. Matter over. Heard Mr. A. Ganguly, the learned counsel, appearing on behalf of the petitioner. So appears on behalf of the revenue. Respondent number 1. And Mr. J. Hendik appears for the respondent number 2, 3, and 4. The case of the petitioner herein is that the petitioner's father, late Sudhanshu Mohan Pandit, was came into possession of government land measuring 1 biga 3 katha 1 lecha under old Dag number 345 of village Gotlong under Moza Bhoirav Pod under Tejpur Revenue Circle, Hunitpur, Tejpur, around the year 1980. The father of the petitioner thereupon continued to remain in possession of the said land and paid the Tozi Bahiri, which is the penalty in the for which it had paid the Tozi Bahari public Bedokhali Zorimona payments. The father of the petitioner also constructed a kacha house on the said land, as he had no other land in his name. After the death of the father of the petitioner also continued to pay the Tozi Bahiri oblique Bedokhol Zorimona and have been issued various receipts. Footstep. The petitioner also applied for settlement for allotment of the said land. Footstep. The Land Advisory Committee, Tejpur, headed by the Deputy Commissioner Hunitpur, had taken had in a resolution number 31 in its meeting held dated 10/2/2021, 11, recommended that the petitioner to be allotted the said land Pursuant thereto, the circle officer, pursuant thereto, the deputy commissioner, Punitpur, issued an order dated 13/1/2012 that the land measuring 1 biga 3 kata 1 lecha under Dag number 345 village Gotlong, Moza Bhoirav is allotted to the petitioner. And the circle officer was directed to hand over the possession of the said land and submit a report after correction of records. It is further seen that the Deputy Commissioner, Punitpur, thereupon also issued a communication to the Additional Chief Secretary to the Government of Assam, Revenue and Disaster Management Department, intimating the said Revenue Department that necessary approval be given for settlement of the aforesaid land measuring 1 biga 3 kata 1 lecha in favor of the petitioner. Subsequent thereto, in the year 2017, a communication was issued by the Joint Secretary to the Government of Assam, Revenue and Disaster Management Department to the Deputy Commissioner, Punitpur Tejpur, asking as to whether, seeking a clarification whether the proposal is for allotment or settlement of land. Thereafter, as nothing further progressed as regards the settlement of the land to be made in favor of the petitioner, the petitioner has therefore approached this court by filing the instant writ petition. It is seen that the Revenue Department of the Government of Assam has filed an affidavit in opposition, wherein it has been mentioned that the Subdivisional Land Advisory Committee, subdivisional, na? Is the had found that the land should be given for allotment, and as such sought for a clarification by the communication dated 24/2017. It is further seen that the Revenue Authority, in filing the affidavit on 19th of December 2023, puts the blame upon the Deputy Commissioner on not giving the proper clarification pursuant to the communication dated 24/2017. And it is under such circumstances the question of settlement of the land in favor of the petitioner remains in a status quo mode. I've heard the learned counsels appearing on behalf of the petitioners and as well as the counsel appearing on behalf of the. This court had put a specific query upon the learned counsel appearing on behalf of the Revenue Department as well as the Deputy Commissioner as to whether the provisions of the Assam Land and Revenue Regulation as well as the settlement rules provide for granting of any allotment or it stipulates that the land requires it can be settled. The learned counsels appearing on behalf of both the respondent authorities submitted that as per the Assam Land and Revenue Regulation as well as the rules framed therein under, the authorities, the Deputy Commissioner has been empowered to settle the land. Be it as it may, it has been duly submitted, drawing reference to the land policy of 2019. Where is it? More particularly to clause 1, that the land would be settled, where land would be allotted and would be initially allotted and thereupon after 3 years of continuous physical possession by cultivating the same cultivating the land may be settled with the allottee, provided the land is being found to have been used for the purpose for which it has been allotted. Further, referring to clause 3.1 of the said land policy, the learned counsel submits, the learned for the respondents further submitted that the said clause applies that similar provisions are duly incorporated in respect of allotment oblique settlement of the land for homestead purpose in rural areas. You come under rural?
Yes, full village.
Village.
Outside the town. Within the 3 kilometer radius.
Village. Village. Pusto. And the allotment can be made by the Deputy Commissioner. Na? Pusto. It has also been submitted during the course of the hearing that the Revenue Department had specifically empowered the Deputy Commissioner to allot lands after the recommendation being given by the state level land advisory committee. Isn't that Mr. Hendik? Because I remember somebody making a statement earlier.
3.3.
There is some notification to that effect. From the above materials on record, it transpires that the petitioner herein was granted an allotment as far back as on 13/1/2012. Of a plot of land measuring 1 biga 3 kata 1 lecha under dark number 345 in village Gotlong, Moza, Bhodabgun, Pusto. This court further duly takes note of that though the settlement rules are silent, the regulation, Assam Land and Revenue Regulations 1886 as well as the settlement rules framed therein under are silent as regards allotment. of land. But taking into account that the land policy of 2019 is an executive, is the policy of the state, wherein it has been categorically mentioned that if a person is in granted an allotment and he puts to use the said land for the purpose for which the land has been allotted for 3 years, he has a right to be considered for settlement. Under such circumstances, this court directs the respondent authorities to take appropriate steps to finalize the settlement of the land of the petitioner, appropriate steps to finalize the settlement of the land of the petitioners. After verification, only to the extent as to whether the petitioner have put to use the land for the purpose for which the land was allotted. The same be carried out within a period of 3 months from the date a certified copy of this order is served upon the Commissioner and Secretary to the Government of Assam Revenue Department and along with a copy to the DC.
Not commissioner and secretary, the principal.
To the Principal Secretary, Government of Assam, Revenue and Disaster Management Department, as well as a copy to the Deputy Commissioner, District Commissioner.
District Commissioner, Sonitpur.
My last order dated, note was directed to the 3G note 3.
Yes. PA. Mr. C. Borga, who is the competent authority?
Additional.
Additional Deputy Commissioner. This is for this land. Now, what is the question out here is, there was a particular question involved, yes. Mentioned in the state communication, there are 15 additional plots of. Now, what has happened? What has happened in your case? What do you want?
Wanted to have the look at 3A notification.
Huh?
3A notification, you know,
Ah.
wanted us to.
Case was, my lord, earlier land was acquired only.
Directing
1
the
acre,
respondent
7
authorities
lesson
to
and
pay the appropriate
for that-
compensation for the B schedule land in proportionate with Schedule A land under the National Highways Act. What is B schedule?
Excess land, my lord, 4 biga, 1 kata, 13 lesson.
So this land was also taken.
My lord, earlier 1 biga 7 lesson was taken, and that for that purpose we compensated, we received. But they acquired entire plot, my lord, excess land 4 biga 1 kata 13 lesson, that is why this case.
Huh?
4 biga 1 kata 13 lessons of land, my lord, they excessively acquired. They take possession, that is my case, my lord.
They have taken possession without following due process.
Due process 4 biga 1 kata 13 lesson. And by process.
Now,
1
for
biga
this
7.
additional land, Mr. Nath, on the last occasion, if you appeared, when I was taking up in the year 2000, long time back, 24 January, we are in the month of August. I hope it doesn't go to the next winters. Yes. Then it was a question out there to the effect that you are putting for this additional
Additional excess land, my lord.
additional sanction for the excess land. And it was being put in the Bhumi Rasi portal. Then what happened?
So the ministry has the The gazette notification, published. It was published on 3rd of July 2024. And
What does it say? That the petitioner land is included?
Yes.
Then obviously the law will take its course. Then what happens? Nothing else. It is being acquired if it is under 3A. Law will take its course.
The director of supply a copy, my lord, because when 3A notification is done, then survey is to take, and thereafter I have given an opportunity to hearing the objection within 1 days after.
Yeah?
The letter which is
What is your DAG number?
266,
2?
266, internal page in the gazette notification.
Support chaos
Yes, sir. Support queue.
0.4093
Yes.
hectares. So it is there in the,
Serial number 5. Page number 5, serial number 7.
it's a
Very-
3D notification. You get the money.
Very much, very much.
Get the money, go there. In fact, your client must have got the money and have not informed you. Which is the sad part of life.
About the next page, the paper publication is also there. In a
He
newspaper.
must have got the money and asking you to fight tooth and nail here. Because you came before this court at a time when there was no proceeding. They initiated the proceedings in my order of 4/1/2024. Then they came up with the 3A, 3B, 3C, 3D. Now 3D is also gone. They must have got the money and they have not informed you. See,
We have not received money, my lord. I have not received money, my lord.
they have not received money, you will get your money. Don't worry.
I am approaching the office, my lord, but
Huh?
I am approaching a office, but
You
yes,
personally?
my client,
Huh?
visiting the office, but
Then? What is the DAG number?
But in the
66, my lord.
266.
in the writ petition, paragraph 3 may kindly listen. Paragraph 3, page number 5.
Para 3.
It is in the name of Sepok Keol.
Was the original patadar of Lajang Sopok was the Iman covered by annual Kiras Patta number 58 of Suiman. Then revenue uploaded as Suiman. Died in the year Iman. Then Aadhaar card. Now, kindly show me this land notification 3D for 1 bigha 7 lesa. Where is that?
That is not in my hand, my lord. 1 bigha 7 lesa earlier they have acquired. I have entered into agreement, and for that I have received the compensation.
No, then also there will be some notification.
That notification was not supplied to us, my lord. And
Next slide.
Chalo. We closed enough. Here, they will give it here. They have.
Page 25 of the writ petition.
Now, where is the earlier notification?
Notification, they have not.
You have a copy? I think it may be. Huh? The documents here. Mr. Nath, the land which is the question is, you have taken is 3 bighas, 5 lecha.
But I have the report of the circle officer.
Ah, how much?
As regard the additional land. Uh, this,
Because you see, 0.4093 hectare is equivalent to 44,560 square feet, which is equivalent to 305 lechas, which would be 3 bighas, 5 lecha. What is this 4 bigha, 1 katha, 13 lecha is saying?
in fact, in the proposal, what I have seen, Lord, I'm just placing it before Lordship. The area in acre, they have, the circle officer has mentioned as 0.4093 acre.
No, his allegation is that they have taken the possession of 4 bigha, 1 katha, 13 lecha.
But
So you come up with an affidavit clarifying this, along with this, how much additional land you have taken and how much is in your occupation. We have not occupied beyond that.
1 bigha already taken.
1 bigha is okay, but here he says another 4 bigha, 1 katha, 13 lechas. Now the question is whether if we go by this 4093 hectare is equivalent to, as I said, 3 bighas, 5 lechas. Would that is that the only land you have taken in occupation? File your affidavit. I think that is the will clear and bring on record this thing. Huh? The instant repetition came up before this court on 24/7/2024, whereby this court sought for instructions as to whether a notification under Section 3 small a of the National Highways Act 1956 have been issued, whereby the additional Deputy Commissioner Dorong Kamkala Mongoldoy the Deputy Commissioner was duly appointed as the competent authority for land acquisition. Today, a notification dated 11th of December 2019 have been placed to show that the additional Deputy Commissioner Revenue Dorong have been duly appointed as the competent authority for various lands, including the land falling with subject matter of the instant proceedings. In furtherance to the order dated 4/1/2024 passed by this court had inquired with Mr. D. Nath, the learned counsel appearing on behalf of the district administration, PWD or district? PWD, as to whether any notification has been issued in terms of in respect to the land which the petitioner alleged, in respect to the Schedule B land, which the petitioner alleges to have been taken over without following the due authority of law. Mr. D. Nath submits that that as regards the additional land, which is the subject matter of additional land, which have been mentioned as Schedule B, an area of land measuring 0.4093 hectares have been acquired by issuance of notification under Section 3D of the National Highways Act 1956. Full stop. Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner, however, submits that the area which have been mentioned in the Section 3D notification is not the entire area which is mentioned in Schedule B. This court, however, taking into account the above, directs the circle officer the district, the ADC, Mongoldoy, revenue to file an affidavit insofar as the acquisition proceedings in respect to the Schedule B land and how much of such land have been acquired. In addition to that, the said affidavit shall also give a clarification as to how much of land have been taken over, possession of how much of the land in that number land have been taken possession, additional land have been taken possession of. List the matter again on how much?
In the first week of after
What is this?
I hate the this is what 46. I integrity application also include. This is my thank you of the name of any. I learned it will take another route with the division.
Is an IA? Okay. List the matter again on 31st?
August,
Yes.
let it be on 6th of September.
No. These are small matters.
I have-
File your short affidavit. I don't want long. This I would have got it at 31st. We have a long short time, 15 days, 31st of August 2024. IA kon lekhok. Mr. C. Bolwar, the learned counsel appearing on behalf of the National Highway Authority of India. And Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner. The instant application has been filed by the
Forget NSA.
National Highway Authority of India for striking out of its name in as much as regards the acquisition proceedings or the project in question, which is the subject matter of the acquisition. The NHA, National Highway Authority of India, has no role. Mr. Dinath, the learned counsel appearing on behalf of the PWD NH division,
PWNS division.
submitted that it is the PWD NH division who is taking out the acquisition, who is the requiring authority for the purpose of construction of the road. Taking into account that the National Highway Authority of India has no role to play, this court therefore strikes down the name of the respondent number 4 from the array of the parties in the accompanying petition. Full stop. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties by 19th of August 2024 before the registry of this court and the registry shall, on the basis of the instant order as well as the memo parties to be filed, shall make necessary correction in the cause title of the writ petition as well as also upload the same in the CIS.
Obliged.
I disposed.
Welcome to Bailey.
Let me your
Let the these petitioners are sought to be evicted from the shop house they are having, land and the shop house. The notice, they have not described it. How much area, what is this? Kindly see at page 48. Here, there. This site for last century, from 1911 itself, when
Hmm?
the market was first sought to be established there by then Deputy Commissioner Mr. Hutton. So from that time we are there by constructing houses. We were initially granted patta, kacha patta, but subsequently an area was settled with us. Those pattas have also been issued, annexed here too. Find. They're there. Page 31, Lordship will find 33, the patta, the vernacular original. 11 lessons. Land has been settled with us. Just in front of them, we have another 9 lessons having so-called. That is in the market area. Now they want that we should be removed from it. We said, why? They say that they may expand the road. But there are others also. The market area. Whether market will exist there? If the market exists, then how can I be evicted from there? If at all they want to shift the market, then we will have to be allotted another place. We'll have to be allotted another place. How can they just remove me and deprive me from my livelihood? That is my question.
But you have no right to settlement of this land.
No, I am not asking for settlement, man.
Oh, but then also you cannot remain in possession of a roadside land.
I have a right to possess it because this was the bheti, the market bheti given to us. The market, not now. It was started in my forefathers in 1911.
Who has
Come
given
to
it to you?
market.
Who has given it to you?
Then Deputy Commissioner.
Where is it?
They opened it, they brought us there. Thereafter, this went to the local board. Local board issued kasapatta to us. That is the bheti settlement.
How can a kachapatta be issued by a local board?
Well, at that time, local board was the management. Local board was the management. Subsequently came this municipality, what they call it, Mahakuma Parishad. Mahakuma Parishad took over.
Whatever may be, it's a
Now it is
roadside.
the town
No,
property.
Mr. Mahto, it's a roadside land. So roadside land, there is no question of settlement.
Well, I am not asking for
No,
something.
but then also you cannot remain in occupation.
Well, unless they provide me alternative.
They provide you that is
They
then
must follow certain procedure. Well, kindly say 18.3 notice, nothing has been given. Simply saying that you will have to go. Will evict you by force. I think, well, that is not permissible in law. They should have at least given me the opportunity
they've given you 15 days time.
to remove myself.
Yes.
So, well, that is arbitrary, well.
That can't be
I am not-
arbitrary.
I am
15
not an
days time is
enforcer.
good.
Kindly see, well, I am not an enforcer, entered into the land on the other day. I am not an enforcer. Kindly see these all documents I have placed. So long position.
Now, whatever may be, you may have been given anybody, but the thing is, you may have been given in 1911, but the thing is 1886, the land and revenue regulations have come, 1894, what you call the settlement rules have come in
That is why I am
19.
saying, my lord. That is why I am saying, my lord, kindly see. If they say, they will have to issue a notice to me at least,
Notice has been issued.
showing the reason what for it is required. Why
Not
should I
necessary.
be
It's a
evicted?
roadside land.
Are they, no, it is
It's
not
a
reserved for.
roadside land which is being care of the
Lord,
government land. You
Lord
have no
above.
right.
Kindly bear with me, my lord. Had it been a reserved land for roadside land, better would have been different. The market reserved for market.
Where is it? Show me. They say that it's a roadside land.
No. Road is there, but thereafter the market begins. Market begins.
No, whether it is
It
a
is not
roadside reservation, roadside land or
Roadside
not.
in the sense, well, by the side of the road, there is a market. And market area is earmarked. Market area is earmarked. I am within that market area. Now, the market has not been evicted from
What
there.
market is that?
Sorry,
What market is that?
Kanpur, New Kanpur market.
Now, New Kanpur market, is it delineated by any boundaries?
Should be. There should be.
No. I'm asking you. Whether
Yes,
it was
it-
done or not, I'm not concerned.
But-
You said it to be a market area, it has to be then delineated by some boundaries. Where is it?
Yeah, land given this list.
So there will be
We have
some document to that effect.
4 bighas, some land was earmarked for the market. This was market area was demarcated and this was, say, this was accordingly, market was established there over that land. And it is running as such from then. Now, if they want to replace us, there should be some consideration that how these people will earn their livelihood. How these people will earn their livelihood. I am not an enforcer. Otherwise, 18.2 would have been applicable. Now 18.3 notice must be there, reason must be so. They must have a scheme at least that these people are now removed from there. How they will survive? Let them have some alternative.
No, this is not an 18.2, this is an 18.2 proceedings.
18.2, how can it, does it apply?
Why?
18.2, I am not an enforcer.
It's not required. Anybody who is in roadside land can be evicted.
Is it so fixed? Let the government show that this is a road reserved, I mean, the land reserved for the road only.
So
Not that.
why should this court look into those aspects?
How
You
do
go
I
there
know?
before the deputy commissioner, let the deputy commissioner decide.
Lord May said that Deputy Commissioner should look into it, we'll approach it. But they should not cross like this. Kindly see, it is not a case. Huh? We approached the Deputy Commissioner also. Kindly see at page 53. We approached the Deputy Commissioner also. This was the
Your thing is, you said something else in your, you say that this is your patta land.
Patta land is there. By the side of the Patta land, the market area begins.
No, you say, kindly see here, Your Honor, page 53. Your Honor, it is important to state an eviction notice so as not to evict us from our Miyadi land till the veracity of Miyadi Patta lands are looked before evicting us. This is your statement.
Not
Well,
the Miyadi land.
You say that.
That this description that they have mentioned about probably not in a proper way.
No, they have not,
By the-
this is what it
By
should
the
have been
side
done.
of, by the, not from that Miyadi land. Patta has been granted to me. They are not evicting me from that land. That is where my residence is there. The Patta land. Patta has been granted to me. I have no grievance on that. They have not touched that. My position is just in the frontage, in the front yard of my house, attaching my house, residential house, there is an area of 9 lessons. There exists the market area, my house, my market house. Shop houses are there. From there, they want to.
Your specific thing is the Kanpur circle officer had changed the DAG number of the below described scheduled land to 234 and is trying to convert the Miyadi land into government land. This is your stand, which is completely contrary to what you are submitting.
That is my instruction was, but here they have written. This is
Your
not,
instruction, I
this
think
is-
you
this
have been
is-
instructed
because
wrongly
my
by
case
your
is-
instructing
Yeah.
counsel, which is contrary to what is
the
there.
instruction was, that they are not touching me from my residential house. They are not saying.
And that is what you are saying. Kindly don't do us anything about the Miyadi land.
Well,
That's it.
Miyadi land is there.
But that is nothing to do as regards the other market. This is not your stand.
My lord, what they say, they have understood that time that this land,
They have
34,
understood.
this land has been converted to DAG number 24, it has become Sorkari. That is what India, Assamese person lordship might see.
Hmm.
That first paragraph.
Read it.
তফচিলৰ মাটিত কামপুৰ চক্ৰৰ বিষয়ে আমাৰ অজ্ঞাতে ম্যাদী মাটিত 234 নতুন দাগ বনাই আমাৰ নামত থকা ম্যাদী মাটি চৰকাৰীকৰণ কৰি আছে আৰু আমাৰ মাটি গৌৰৱ পথত নিব বিচাৰি আছে। কি লিখিছে এইটো? পথত নিব বিচাৰি আছে। কামপুৰ চক্ৰ বিচাৰি যোৱা ইমান তাৰিখে ইমান নম্বৰ নিৰ্দেশযোগে ইমান নম্বৰ পথৰ কাষৰ মানুহে মাটি এৰি যাব লাগে বুলি ইমান নম্বৰ পথৰ কাষৰ মানুহে মাটি এৰি যাব লাগে বুলি 15 দিনৰ সময় কিবা বান্ধি দিছে।
So all the people, Lordship, within this trace, Lordship,
Okay,
নিৰ্দেশ যোগে 2, 3, 4 নম্বৰ পথৰ কাষৰ মানুহে মাটি এৰি যাব লাগে বুলি
Only
15 দিনৰ সময়সীমা বান্ধি দিছে, not only them, the other persons.
But
are
others
also
have not been issued notice. This has been given only to these two persons. That is my
Indian Lordship 18(2) is a-
I'm
So-
not, these are 18-2 proceedings.
My response submission 18 to Lordship is aware about, it applies to if the land is reserved for some public purpose.
No,
would have
it reserves,
included
it
And it is an
nowadays
enforcer.
applies for all lands after
All
the
land is
97
an
amendment.
enforcer. If the person is an enforcer,
Yes. No, anybody who is in occupation of government lands, that's all.
well, why we have enforcer?
No, where
That
is
is
it,
what I'm saying.
where is it said
well,
about encroachment?
Here, kindly see, my lord.
You have no right, only,
Well,
if
I am
you
not
dispute
well,
that yes, there is, this is not a roadside land, reserved land, then it's a different aspect.
My lord, road is going nearby.
No, you,
road.
but it is not your case from this representation that this is not a roadside reserved land. If that is your case, then the question would have been different. I would
Well,
have said,
well,
looked into that.
My response submission is, these persons have given this, what they have understood from the oral version of the persons, the Mondal and all who went there.
Are you saying that they became clever after meeting your junior?
No.
Then?
No, when they were asked where from you are going to be evicted, then they describe all these things. That is how the case has been made,
Now the case is being differently made.
because that was the instruction. They have this land with their.
Your
houses
basic
there.
thing is that kindly don't disturb us from where we are residing out there, nothing to do with this.
Well, exactly. Had it been a case of disturbing me from my residential house, better would have been different. It is not. That is why I am not claiming a right, that I have a right to be
Oh,
subject.
whatever may be.
I am not
You
claiming
may approach the authorities concerned for alternate, they may consider it. I may pass an order to that effect that they will consider it, but not to the, if it is a road to be done, they will do it.
My lord, let them show to what extent, how much land is reserved for road. Because the market area, as I am saying, it is reserved for market.
Mr. Monto, this court is not going to convert itself to
No.
an office of the deputy commissioner. Kindly
That is what I am
appreciate this.
saying.
No.
This is what I am saying.
Because
Let the
your
deputy-
your statement before the deputy commissioner is completely different, and now you are asking this court to exercise. No, nothing.
My response submission is, let the deputy commissioner look into it and make a survey and find out. When a grievance has been raised by some citizens.
Your grievance, if it is seen from the representation, is completely different from what is there in the
I
petition.
agree, my lord. But I cannot conceal the real facts. I am placing the real facts before your lordship. So what
No,
happened?
which facts then do I have to believe?
My
The facts which is there on the affidavit, or the document which is enclosed supported by an affidavit?
My lord, the notice which has been issued, it doesn't say that I am going to be evicted from that land, that my house, where my house stands, here in the patta, nothing.
Roadside PWD DAG number 234.
That is what they
That
say.
DAG number 234, if it is there, they can evict.
They-
Otherwise, nothing.
That is why, my lord, they were under the impression that it includes their house, but in fact not. That is why, when the documents reveals that there is a land only for the market area. They are not going to be evicted from their house, that is there. But the market area where they have the shop houses, from there only they are going to be disturbed. That is what I am now praying before your lordship. Let the deputy commissioner look into it, because they have not specified the area. What is this? Kindly see the notice. Notice has not specified the area, nothing.
Now, I
Simply
can
says-
only pass an order that they will only evict you from the after making a demarcation as regards the roadside land. That's it. That is the only relief.
Let them demarcate, let them find out.
No, they will demarcate out the roadside PWD DAG number 234 and then evict.
Then take the call.
Then
Otherwise,
they will evict you. That is the only thing I can give it to you.
what should I, he should have said that, madam.
That is the only thing.
Yes, well, here what my grievance is, they have not gone into the demarcating, even marketing, lordship kindly record.
No, I have nothing to do with the market area. My simple question is, here there is the notice which says roadside PWD DAG number 234 is the schedule of land. If they will, the authorities before carrying out the eviction proceedings shall do so after making demarcation and find out that this is a roadside dark number 234 and then demarcate.
Yes. Well, Lordship, may kindly my contention that they are in possession of the shop's house in the market.
That has no relation. The moment I do it, I'll reject your contention and then go ahead. I'll go reject your contention. But only that is this. You have been there for so long, hardly
My
matters.
contention is the market area.
First of all, there is no question of settlement or anything unless you, no, Mr. Whatever may be, tomorrow anybody can sit in the roads.
No, my
No,
lord.
anybody can sit
I
in the
would have-
road if
Frankly.
we are to interfere in this type.
I
No,
wholly agree to it, my lord. I wholly agree to it.
one has to be very careful on
I-
these
I-
aspects.
I wholly agree to it. Had it been the case, I would have definitely said before this honorable court. But this is a case where these people are there since 1911. Lord will kindly.
Very good. 1911, they have been there. They have already spent 140 years, 14 years out there. Very good. Now
Now-
let them give away to the road.
Now, that is why, my lord, if they want that market area also for the road, at least they should provide me some
Or
alternative.
you do one thing, let them carry out here. I will direct the deputy commissioner to provide you some other place where they could provide some other alternative so that they can go ahead and do business.
True, my
You
lord,
want
that is
that?
what I am
That
asking.
is the only way I
If
can
at
do it.
all they want this land, at least they should provide me some alternative.
No, immediately you have to be removed. First, the thing is you have to be removed. Thereafter, the question comes of providing. I'll do one thing. I'll issue notice asking them to, the deputy commissioner to,
Survey.
no survey business, to remove you from there and ask him where to, they have a place. They will
Now,
provide.
before that.
No,
that,
no,
Lord will
before that.
kindly say that
Tomorrow you will come up and say that my
Even-
sealing
even
out
if you're
the asbestos things and I've not got it till now. So let me get that also.
No, that is why
Nothing doing.
What I am submitting before Lordship is, the deputy commissioner should find out the area, whether this is reserved for roadside land. And then if find, they may take the call and alternative, Lordship may direct, they may find out some alternative to replace it.
Notice making it returnable on 27th of August 2024. Get your information. 27th of August 2024. Mr. Ms. Swenso appears on behalf of the Revenue Department and Mr. H. Sharma appears for the respondent number 2 and 3. As the respondent numbers 1, 2, and 3 are duly represented, extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 4, the petitioner is directed to take steps by way of registered as well as usual during the course of the day. In addition to that, the respondent number 4 is further, the petitioners are further directed to stick to effect service upon the respondent number 4 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next. How will it get served? Kamalpur Municipal Board, Nagaon, the executive officer.
The executive officer is there.
Can it be served by way of postal?
Hello, Dusty also.
There's no address. What address is this?
At the municipal board at Kampur itself, that is a indicative, probably that's how.
Where is the Kampur?
Kampur Municipal Board.
That is enough.
Nagaon.
Nagaon, there is Kampur. Nagaon, I think it's in the district.
Nagaon
It is-
district, they are after about 46 kilometers away.
Very well.
Kampur. That is Kampur. Kampur Municipal Board. It is known to everyone.
The case of the petitioners herein is that the petitioners, the forefathers of the petitioners have been doing business in an area of land at measuring 9 lechas,
10, 12.
which is
My lord, petitioner. 8 lessers and 2 lessers. 2 petitioners are there. 2 petitioners. In one's possession, it is 8 lessers. And other one is petition number 2 is 2 lessers.
8 lessers and 2 lessers. Since 1911. Pusto. All this while, they have been doing business since generations, which comes under the Kanpur Municipal Board. The petitioners duly admit that the land wherein the petitioners are carrying on the business are not their land. Be it as it may, on 31/7/2024 and 1/8/2024, the petitioners have been issued notices by the Circle Officer, Kanpur Revenue Circle, that they are in occupation of the government lands, government roadside land, and as such, asking them to clear the land within 15 days of the receipt of the said notice for construction of the Gaurav Road, failing which eviction would be carried out in accordance with law. It is seen that the petitioners had submitted some representation on 1st of August 2024. However, a perusal of the said representation prima facie appears to be contrary to the case pleaded in the writ petition. Inasmuch as the stand taken in the representation is that the Circle Officer of the Kanpur Revenue Circle is taking steps to convert their land into government land for the purpose of construction of the Gaurav Lane, and as such, requesting the District Commissioner to state the said eviction notice. On the other hand, it is being submitted by Mr. K.K. Mohanto, the learned senior counsel, that the respondents' authorities are not disturbing the petitioners' area where they are residing. However, in the marketplace, which is on the road, and the petitioners have been carrying on the business from the last 100 and petitioner as well as the forefathers have been carrying on the business for the last 14 years. They are trying to evict the petitioners without providing any alternative, making any alternative arrangements. It is the case of the petitioners. It is the case as submitted by Mr. K.K. Mohanto, the learned senior counsel, that the petitioners cannot be rendered on the streets without providing an alternative area where the petitioners could carry on their business. On the other hand, Mr. H. Sharma, the learned counsel appearing on behalf of the respondent number 2 and 3 submitted that notice, that the notice had been issued giving 15 days time to the petitioners in terms with the judgment of this court in the case of Salakuddin versus so-and-so reported in so-and-so. And it is a proceedings under section 18(2) of the settlement rules. He further submitted that on the materials on record would show that there is not that the petitioners do not have any semblance of any right over the land in question. And more so, when the land in question is a roadside land. Which under no circumstances can be settled in favor of the petitioners in terms which Rule 23 of the settlement rules of framed under the Assam Land and Revenue Regulation 1886. He submits that any stay granted to the eviction proceedings in a case of the present nature would derail the said infrastructure project. This court upon hearing the above, the counsels and also upon perusal of the materials on record, do not find that the petitioners herein have been able to show any semblance of right or even a bona fide claim of right in respect to the land wherein the petitioners have been carrying on the business. Merely issuance of certain receipts by the Kanpur Municipal Board would not, in the opinion of this court, grant an impunity to the petitioners to carry on the business on the land belonging to the state, more so a roadside land. Be that as it may, this court, however, observes that if the land in question is not a roadside reserved land, then in that circumstances, the petitioner still has the petitioners can be accommodated for a certain period till their alternative arrangements are made. Under such circumstances, this court directs that the respondent authorities may go ahead with the eviction. But prior to doing so, the respondent authorities shall ascertain that the land in question, in respect of which the notice have been issued, is a roadside reserved land in the records. This court also cannot be unmindful of the fact that the petitioners who are doing business would be rendered, would have to be who are doing business would be uprooted if an eviction upon the eviction being carried out. The Deputy Commissioner, District Commissioner, Nagaon, shall on the returnable date shall in the meantime make an assessment where the petitioners can be accommodated so that they can carry out any business and the same be placed before this court on the next stage.
From the record, it reveals that they are doing their business from 2016. Page 40.
তাতে H. Sharma এটা লিখি দিব হ্যাঁ একটু মানে Mr. H. Sharma further submits that that it is that though the learned senior counsel appearing on behalf of the petitioner states that the petitioner have been doing business from the year 1911, but from the documents which have been enclosed to the writ petition shows that the petitioners have been doing business from the year 2016.
And Salakuddin Lordship WBC 1057/2022. That the Lordship may also refer to these receipts I have shown Kanpur Nagar Committee, Kanpur Town Committee should that time itself permission to me to raise those.
No, it is his submission. I have not given a finding to that. Therefore, he says that I put it in his submission that he says that although the senior counsel have stated this, but from the records it shows. I'm not opining anything, but my opinion is let them go ahead, but first to ascertain that it is a roadside land, and then they will go ahead. And secondly, on the next day, they will give us something.
Or whether this is a market area land.
No market area land. Now, market area does not arise out here.
This notice itself shows.
Another notice they have
That
annexed
page,
Lordship
Lordship,
whereby
that's
the
what
other
I-
people, except them, the other people has also submitted a representation before the deputy commissioner that we may be allowed sometime so that we can go out from this.
No, I've asked you, but
Yes,
moment
Lord.
you find out this is a roadside land, you throw them out.
I will get that instruction on 26 Lordship.
For your Lordship satisfaction, just a glance on 37 page. Lordship will just. have a glance.
No.
It says.
This is a matter which I have taken out of turn. So let me
True.
take up
I'm
with
grateful,
that.
man. I'm grateful because nature is such, if it is nature is such, they have announced that they will be thrown out tomorrow. That is the difficulty.
But the thing is, they should not have approached you so late.
But they were trying before the authorities there.
No, you submitted on 1st of August.
Yes.
And thereafter you have come such a late time. We are on the 15th, 14th you have come.
But that-
Tomorrow is the 15th.
People can appreciate these traders. They do not know all these niceties, records, everything, where they are lying, what is this. That's why they made a statement which doesn't tell you which is records. Grateful, man.
Yes.
Well, at page number 11 is the order, a Lordship order amendment.
Oh, correction.
Yes, well, at 11,
What
page,
happened?
page number 15, paragraph 2 and 4, my lord. The date is mentioned 27/1/16, my lord.
The order dated in month passed by the. Is this?
My lord, date is mentioned 27/1/16, my lord. Paragraph number 2 and 4, my lord, in the order, my lord.
What should it be?
My lord, it will be 19/9, my lord. In my prayer, my lord, it was 19/9, my lord. I had challenged 19/9 order, my lord. 19/9/2016. That much is correct.
Instant application has been filed by the petition taking correction of the order dated 15/7/2024 passed in WPC number 7172/2016. The reason for filing the instant application is that in paragraph number 2 and paragraph number 4, the order so mentioned in respect to special electricity case number 5/2010 was mentioned as order dated 27/1/2016, which would have been
9/2016.
19/9/2016. It is already given. Both are 19/9.
Yes, that's the same date.
19/9/2016. Let us see how this mistake. Everywhere it has been given. Oh, wait.
My prayer is page number 14 when I read petition.
Full stop. This court, upon perusal of the materials and report, finds that a typographical error had occurred in mentioning the date of the order in respect to Special Judge Electricity Kachar in respect to Special Electricity Case number 5/2010. Inasmuch as the order which had been assailed was 19/9/2016 and not 27/1/2016. Accordingly, this court therefore rectifies the said error by observing that the mention made in paragraph number 2 and 4 of the order dated 15/7/2024 insofar as the special electricity case number 5/2010 as regards the date, that is 27/1/2016, be read as 19/9/2016. The instant order shall be a part of the order dated 15/7/2020. Passed in demolition after 7172 of highest in district. Yes.
Your lordship, relating to a your lordship tender, your lordship, issued by IOCL, your lordship.
Huh? The 25% allocation result from micro. Yes.
Now, your lordship, what has happened here, your lordship, if your lordship comes to page 21, it is the,
Who are before this court?
your lordship, these are the petitioner is the one of the bidder, your lordship, who has participated in the bidding.
You did not get.
I did not get.
How many trucks? Well, what is the business of?
Your lordship, this is your lordship, tank trucks, your lordship, for your lordship, transportation of your lordship.
Oil.
Oil.
Then why
All
you
together,
you were not given?
Lordship, they have your
Who is
lordship.
Indian Oil Corporation?
the
Why
entire
you were
requirement-
not given?
Also, the entire requirement of 32 trucks got exhausted.
Huh?
The entire requirement of 32 trucks got exhausted. The petitioner was at serial number 18, my lord, and L1 to L5. From them only the trucks were required. So there is a condition, my lord, in the tender. My lord will kindly look at
Page
page
31.
89.
Page?
89 of her reply, if it in opposition.
Yeah.
My lord, top portion, point number 4. The TT shall be
It shall be
selected.
Order of the seniority and the size of the concerned and possible that the tenders who are willing to
My lord will look at page 39 of their writ petition. The petitioner is a citizen of female.
then
Lordship, from serial number 1 to 5, from these 5 MSCs, all the 32 trucks are already acquired. my lord. So there was no requirement left. 7.
Lordship, issue is not that, your lordship. Issue is, your lordship, there are, your lordship, out of these 132 tracks, your lordship, 25% is reserved for MSMEs, your lordship. Now, out of this 25, your lordship, 25% means, your lordship, 43 trucks for MSMEs. Your lordship will kindly come to page 32 of my dissertation, your lordship.
30.
32. Otherwise, allocation summary, your lordship. Serial number, your lordship, NIT requirement 169, SC so and so, ST so and so, MSME total 25%, that is 43. Out of that, 3% for MSME women, that's 5. MSc, SC, ST 4%, 6, and MSME general, your lordship, 32. Now, out of these 32, how it will be, your lordship, awarded to the contractors, your lordship. Now, your lordship may kindly come to page 31. The issue has already been settled by this honorable court, your lordship. I have annexed that judgment also.
Eh.
In my petition, your lordship. Your lordship will kindly come to 31, your lordship. Reservation criteria B2.
Page 31.
C2, your lordship.
Yes.
The above provision will be subject to MSME quoting price to price band of L1 plus 15%, that is L1 plus 15% in bringing down the price to L1 in a situation where an L1 price from someone other than the MSME. In case more than one such MSME, the supply shall be shared proportionately from the MSC parties. In case the L1 tender MSC party, then the ranking as detailed in the tender shall prevail and not proportionally shared among tender within so and so. Now, your lordship, this how this word proportionally will be interpreted. That's the issue, your lordship. Now, your lordship may kindly see, your lordship, page 57. This is as per the, your lordship, the provision of the public procurement policy for micro and small enterprises, your lordship. Page 57. And your lordship will get it at page 58. This is a mandatory procurement from micro small enterprises, page 58. And then your lordship, page 59, price quotation in tenders. In tender, participating micro small enterprises quoting price within price band of L1 plus 15% shall also be allowed to supply a portion of requirement by bringing down their price to L1 price in a situation where L1 price is from someone other than a micro and small enterprise, and such micro and small enterprise shall be allowed to supply up to 20% of the total tendered value. In case of more than one such micro and small enterprises, the supply shall be shared proportionately.
So you mean to say they required 169 trucks,
Of course.
of which for MSME it was 43. 5 and 6 and 32.
Of course.
Is what
We
it
are
is.
concerned with this 32.
Now, they say that it got exhausted by with the first 5 tenders.
Sure.
So did you only go for 5 trucks?
Sir?
Did you only go for 5
No, my
trucks?
lord, all the 32 trucks were acquired from those. Because my lord, B2, that
Huh?
my senior counsel already referred to, the last line, at page 31 itself, my lord, of the repetition.
Huh.
The last line, the second last line. In case the L1 tenderer is MSC party, then the ranking is,
B2 where? Which
my
you are
lord, page
reading?
number 31 of the repetition. The reservation criteria 12, then B1, B2, my lord. B2, my lord, the first paragraph, second last line.
In
case
case
the
of
L1
more than
tenderer-
one MSME, the supply shall be shared proportionately from the MSME party. In
Okay.
case the L1 tenderer is an MSME party, then the ranking as detailed in the tender shall prevail and
Not
proportionately shared among tenders with the L1 plus 15%.
going by this, my lord, we got all the trucks from the top 5 itself. So we did not approach the 6, 7, 8. Petitioner was at serial number 18, my lord.
So as per this, you went as per B2 the last time. Wherein it says that L1 is a MSME, then the ranking as detailed in the tender shall prevail and not proportionately sent among the tenderers within L1 plus 15%. Is L1 plus 15?
Hello?
What do you mean by L1 plus 15?
That stand is not reflected in affidavit, your lordship. Their affidavit, your lordship, can
This is
take.
a reservation, my lord, provision for reservation. 50% will be for SC, then 7.5 will be for ST, my lord, at the top. On all India basis as per government India. ST and the rest will not be eligible.
Now,
for
what
SC.
does the Justice Bhuyan's judgment say?
Your lordship will kindly see page 63, your lord.
Does it take care of B2, that portion?
No, your lordship, it has your lordship,
Because this must have come a year after that. Yes, so what do you say?
this prior to your lordship, this in respect of some other tender, your lordship. Para 16 and 17, your lordship may.
No, one thing, tell me one thing. You have 169 trucks. Some will be MSME, some will not be in the MSME category. MSME category is 43. Okay. Out of 169. So 120,
169,
126.
20, rest.
126 trucks, that has to go by proportionality. Then how do you take care of that?
He is only concerned about these 32 trucks, my lord, not the whole of the one.
No, but then also he will be entitled to. If a person, are you saying that those 5, you procured all the 169 from them,
No, we only forget 32. 32, my lord.
from these MSMEs, as per that? What about the other? If a person who applied for the MSME, is he not entitled to be taken in the general category?
I'll have to take instructions regarding that.
Mr. Bottakur? Because he comes with that line in that B2.
Lordship.
But what happens if you, is this serial number based upon 1 to 18 or 1 to 22 is only based upon MSME?
Lordship, what has happened, your lordship, so far as the qualifying criteria for MSME and your lordship, others are different, your lordship.
So
therefore,
he
your-
cannot be considered.
Therefore, that will not be
My lord.
considered for MSME, your lordship.
On the list at page 39, it is only for MSC category, sir. He is at serial number 18 of that list, at page 39.
Then how does it here, but in Justice Bhuyan's judgment, he says about both.
He says about, your lordship, only about MSME.
Let
Only-
us see, where does it say?
Your
that-
lordship will kindly come to page 60, your lordship.
The
It
60,
starts from
which
page
is the
70.
relevant portion.
Lordship, page 70, para 16 onwards. your lordship.
There is no dispute the petitioner belongs to MS and for which 6 trucks
Six
were
ten
allocated.
trunks were
It is not
allotted.
in-
It is also not in dispute that petitioner is placed as serial number 5 in the list of MSME. The allotment have been made by considering the number of vehicles offered by the tenderer vis-a-vis number of vehicles owned by the tenderers. Respondent number 3 had offered 5 vehicles, all of them being owned. Respondent number 4, 5 vehicles, out of which 4 were owned at one attacks. As per paragraph 6(2) of the order dated 23/3/2012, the Ministry of Micro.
Now, kindly come this line, the last line of that. This is also indicated in clause B2 of part A of the tender document relating to the reservation, which said that in case more than one's MSME, supply shall be set proportionally from here. But this is different from now. This aspect is contrary to what is stated out here. Here it says, in the case of MSME, it is not required, if I'm not wrong. Where's that?
31, my lord.
Page 31, your lordship will kindly see, your lordship. For that, they will have to show, your lordship, that the MSME was the L1, your lordship.
No. Kindly see it, B2.
The above provision will be subject.
In case the L1 tenderer is MSC, what is MSC?
MSME, your lordship.
Medium and small enterprise.
Party. Then the ranking as detailed in the tender shall not prevail and not proportionately shared amongst the tender with L1.
Lordship, therefore, they will have to show, your lordship,
that L1 tender is MSME, Your Lordship, so far as overall, Your Lordship.
But they are, that list is of that list is of the MSME only, those 32.
That is, Your Lordship. Therefore, Your Lordship, within MSME, Your Lordship, MSME tender will have to be L1, Your Lordship, among the MSME, Your Lordship. Now, this stage, Your Lordship, if among the all the tenders, Your Lordship, if somehow, Your Lordship, an MSME is an L1, Your Lordship, then it will not be applicable. And Your Lordship will kindly see their affidavit. They have, Your Lordship, not come up with that plea, Your Lordship.
No,
What
you
they
want
have-
time for that, that is a different thing. I'm not on that. But his argument is that
Lordship,
this is there, but that judgment of this is Bhuya doesn't say that. Says on the other thing, which is different from B2.
no, Your Lordship will kindly see, Your Lordship, that Your Lordship,
Our position will be subject to another quoting rate for a year of L1 plus 15%. What is this L1 plus 15%?
Your Lordship, normally, Your Lordship, L1 plus what is quoted by the L1 tender, more than that, up to MSC, for MSMEs, it may be up to 15%, plus 15%. Rate, Your Lordship. But ultimately, Your Lordship, they will have to be, Your Lordship, bring down their rate to the L1 tender, Your Lordship. L1 means Your
L1
Lordship,
plus
general L1.
15% and bringing down the price to L1 in a situation where the L1 price is for someone other than and bringing down their price to L1 in a situation where the L1 price is from someone other than MSME. But if their list is only for the MSME, that 32 or 22 where you are featuring at 18, then in that regard, in case of more than one such MSME, the supply shall be shared proportionately. More than one such MSE, supply shall be shared proportionately from the MSE. In case the L1 tender. So if it is a case where the L1 is someone else other than the MSE, then it is to be done proportionately. But in case the L1 is a MSME, then the ranking of the detail in the tender shall prevail and not proportionately spared with the year. But one thing tell me, if everybody has to give at the L1 rate, why you have chosen all the 32 trucks and distributed among some and deprive others?
My lord, what happens is that we go serially from first we approach the.
Understood. But everybody, I would have understood. The moment you go to the second one, doesn't that the right of a third one accrues?
My lord, if the second one cannot provide, if there are more remaining trucks, then we proceed.
Where is that? If the second one does not provide, you can go to the third one. Because then proportionately, if you are to go, proportionality would not apply. But are you proportionately applying to the second and the third one? Then why you are giving the opportunity to the number 2? One is okay. If one is giving 32 trucks, you take it. But if the number 2, not one, how many trucks it will be less? 32. One is giving 32 trucks is okay. But the moment you are going for the one is only giving 5 trucks, now you are going for the next 17. What is the parameter of choosing only the number 2 to number 5 and not others?
My lord, this then the ranking.
Because everybody is going to give L1.
According to ranking, my lord.
Understood. You give everybody why proportionality is not followed from number 2 onwards. If you are going, if one is giving all the way, then proportionality need not be given. That is why it must be the idea. But what happens after one is given, out of 32, one is only giving 5? Why you are only constricting yourself to 2, 3, 4, and 5 and giving them the rest 5 at L1, where the petitioner is also wants to give it from L1 at 1.
That's all, my lord. If L2 suppose gives all the 25 remaining trucks, then we will not oppose the L3.
Why? Where is the basis on that? Under other aspect is okay. But the moment you L1 can give the remaining, can you adopting the okay, we'll only take 2, 3, and 4.
As per the rank.
Mr. Bhattacharya, what do you say on that aspect? Get my point?
We interpreted it, my lord, as that.
L1, if it is given proportionately, does not
Lordship.
apply. But the moment he is going to number two.
Sure.
And what is the basis that it has to be only given to 2, 3, and 5? The entire thing would be over. Unless these tenderers categorically say that we are going to give you so much.
My lord, we have
And your
interpreted-
Because here MSMEs are given only on the basis of certain criteria, they're giving some
Please, 30.
upliftment.
30 will clarify that part.
Page
My lord.
30?
Page 30 of the writ petition.
Yes, what did you say?
Now, my
And
lord,
clause?
from 29, my lord, from 29, last part one, in case of SC/ST allocation of TTs, my lord.
In case of SC/ST bidders.
Now, my lord, allocation of TT preferences, ready available TTs, offers with price, sale invoice of chassis, offers with booking slip, separate booking slip. This is that. Now, my lord, page 30 immediately thereafter. The allocation in the above sequence will continue till location's quota of SC/ST is fulfilled. In case more than one party has quoted same rate, seniority shall be decided in following criteria. Now, my first is average age of the fleet. Now, if your lordship comes to page 39 for a moment, I'll just take your lordship to page 39. Once again, my lord. Now, last column, lordship would find the average of the TTs. The age of the TTs, my lord. The first one, my lord, 305 days only.
Below 12 kiloliters.
Yes, my lord.
12 to 16. What is this? 12 to 16?
My lord, these are kiloliters, my lord. Kiloliters.
The capacity. The capacity.
Correct, capacity, my lord.
Then 18 to 20. 30. Okay.
Yes.
Then
18
average
to 40.
age days on 22nd July 2000 Iman. So there, the petitioners is
The age of the fleet.
10 years.
Yes.
Almost.
Serial number 18, my lord, I would kindly see 3,182 days old. So, my lord, age is taken the criteria because of the fact, my lord, it is going to Tripura, Manipur, Meghalaya, my lord, from the IOC, my lord. So that also they people are checking, my lord. That is why it showed page 30, my lord. Then total volume of all individual TTs, maximum number of TTs shall be 10%. Now, my lord, from a single MSME, they can take maximum is 16, my lord. Not more than that.
Maximum number of TTs shall be
16, my lord.
10%,
Yes, my lord.
including ready built TT and purchase TT of total amount. 16 trucks.
From a single MSME person, maximum 10% off. Because 169 is there, my lord. So
So
169.
thereafter they will go as far, but this is only for SC/ST.
No, my lord. This is overall, my lord.
No. It has a heading.
In case of SC/ST bidders.
Why
Then,
you
my
going
lord,
to this?
just above that, my lord. Just above that, my lord.
What?
Well, page 29, my lord.
Huh.
Roman 11, my lord.
It's okay. This is okay, but this is only for SC/ST.
My lord, just above, my lord, this month, 29, 11.
This is the basis on which you are going to give him the ranking. The ranking you are giving him so low because of that. But what is the basis on which you form an opinion that, okay, number 1, I'm giving because there is no proportion. L1 can give any many. But the moment you are coming to 2, 3, why not 3? 2 along with 3.
My lord, because, my lord, they initially see the age of the truck. So, my lord, at the age of truck,
Who are
my lord,
you? First, who are you?
my lord, 4 to 6, my lord.
My goodness. And an answer from you on that point. First is okay, because if we go by B2, first is okay, if it is a MSME is the L1, very well, you can give it, the entire length. But how do you take care about number 2 onwards? Why 2 has been given 5 or 7 or 8 compared to 3 have been given more or less? It may be a thing that where the third may have been given more. Just find out the allocation being made to all these five. How did it get exhausted? Okay, this is the most criteria, because otherwise it's okay. I understand that. You may have a reason why you may have done it. There might have been the reason. Have you brought on record anything else? Why you have done it? Yes, why five you have done it? Just get your instructions on that. Huh?
Yes, Lordship.
Or Mr. S. Bottaku, upon the petitioner, Mr.
Three Boram. Appearing on
Bora
behalf of Mr.
appears
M.K.
on
Chaudhary.
Huh?
Mr. M.K. Chaudhary on behalf of Mr.
appears on behalf of
IOCL respondent 1, 2, and 3.
IOCL. The respondent numbers 1. Appears on behalf of the private respondents. The petitioners herein have challenged the action on the part of the respondent authorities in not granting the allocation of the TTs, what is the transportation trucks, to the petitioner upon petitioner in a proportionate manner, and have therefore alleged arbitrariness. Mr. S. Bottaku, the learned counsel appearing on behalf of the petitioner, further submitted that though a perusal of the reservation policy given at Roman 12 P2 category mandates that if the L1 tenderer is a MSC party, then the ranking as detailed in the tender shall prevail and not proportionately shared amongst the tenderers within L1 plus 15%. However, he submits that there is no justification given in the affidavit or otherwise in the affidavit as to why after the L1 tenderer could not provide the entire fleet, the respondent authorities have limited the procurement only from the next 4 bidders, but did not grant proportionately to the all other bidders. Mr. So-and-so appearing on behalf of the respondent, IOCL submits that he will obtain instruction in that. When?
Very short date, next week, maybe.
31st? 31/8/2020.
No blessing.
I hope Mr. Bottaku, you have alleged something like that. Fantastic. Yes, what is this?
Non-payment of the ex-gratia payable to the victim of the accident. Husband died in a road accident, Lordship.
Huh?
His husband died in a road accident, Lordship. Policy they do.
Where is the final report?
Final report I.
Huh? When did he die? Hmm?
Our affidavit, my lord, that report, final report is mentioned.
Bolero pickup. Bolero pickup. AS 25 CC 6717. Ito muna ito, judgment ito also. Dismiss. To be of the identity of the vehicle.
Yes.
Monisha Khatun.
Okay, against that judgment, my lord, one appeal has already been filed.
So what? Let them also file appeal.
Yes, that one. Yes, my lord.
Monisha Khatun or it could be. It vehicle is there. AS 25CC 6717. Dismiss. Come to Lulu. Yes, what is this?
My application for demarcation was not considered at that time. Then I have filed this writ petition subsequently on my lord 12/6/2023.
Done.
Done.
Infructuous.
Only my lord, the demarcation case was not disposed of till now, my lord.
Done or what is done?
Demarcation was done physically, my lord.
Third page, man. The vernacular one.
Demarcation done.
12/6.
You have given 10 feet road. You don't accept that.
I've accepted,
So you return the land.
I've accepted, my lord.
Okay. It has been submitted by Mr. A.K. Gupta, the learned counsel, appearing on behalf of the petitioner, that the instant writ petition has become infructuous, taking into account that the demarcation case number 932/2021 have been brought to a logical conclusion on 12/6/2023. This court have also taken note of the parawise comments so submitted by Ms. P.R. Mohanto, the learned counsel, appearing on behalf of the Revenue Department, wherein it is seen that after demarcation 10 feet breadth road was handed over to the petitioner in presence of Swapna Gohai Borua, Josna Gohai Borua, and Gaon Pradhan and witnesses. Therefore, in view of the above, the instant writ petition therefore stands closed as infructuous. Yes, what is this?
Yesterday, I have received the affidavit in opposition filed by respondent number 8,
Respond number?
8, 9, and 10.
It has been submitted that the respondent numbers 8, 9, and 10 has filed an affidavit in opposition. However, the same is not on record. List the matter again. When?
As your lordship.
Do you have any hurry? No.
I am not in hurry, but lordship,
Okay.
there is minor issue. It is that my pig farm was under lock and key since March 2023. There was some direction from the Deputy Commissioner Nalbari to take some remedial measures.
You are in a hurry or no? No.
No, I am not in hurry.
Taking into account the above, list the registry is directed to bring on record the said affidavit. So filed with the respondent number 8, 9, and 10. The petitioner would be at liberty to file the reply. List the matter again on 9th of December 2024.
6.
Yes, what is this? 10 minutes. Where is Mr. H. Sharma? No instructions received.
Affidavit has already been filed, my lord. Affidavit filed, but it is not tagged with a court
And Ms.
record,
M.
my lord.
Borman, the learned counsel, appearing on behalf of the respondent, submits the affidavit has been filed in the matter accordingly. However, the same is not on record. Is to list the matter again on urgency, no urgency. Urgency or no urgency? No urgency. List the matter again on 16th of December 2024. Urgency there? Okay, list the matter again on 23rd of September 2024. In the meantime, the petitioner would be at liberty to file the reply if so advised. and appears on behalf of the petitioner on yes, any instructions? No instructions. The case of the petitioner is that the petitioner have been evicted from the that case of the petitioner is that his house have been demolished and the petitioner have sought for requisite compensation and rehabilitation. This court had issued notice on 26/5/2023. Till date, no instructions have been provided by the government advocate. List the matter again on 11th of September 2024. The council appearing on behalf of the respondents are directed to obtain necessary instructions without fail. Yes, Mr. Sharma, Oil India, what is it doing?
This is a matter regarding acquisition of land and a dispute regarding the timing of an award for compensation. When was that award passed? And there have been multiple litigations in this matter. As of now, Lordship, the respondents have filed their affidavit. Respondents in the private party, the beneficiary. They have filed their affidavit. I need to file my reply. As well as the government has to file their affidavit.
Government getting an affidavit is next to impossible.
Because ultimately what is to be decided is whether the award, we are saying that the award for compensation was passed in 2011. But they are saying that no, there was no award passed and therefore 2013 Act will apply. And accordingly, they have proceeded to pass an order whereby a huge amount of compensation has now been awarded against Oil India for acquisition of a particular land.
Who has awarded?
The Deputy Commissioner. Our dispute
Under
is
what provision?
under the 2013 Act. Our case is
Fair
because the
company.
acquisition of 2000, the year 2000, there was
The
the
matter come up before this court. Not once.
Lordship had the occasion.
Ah, yes, yes.
The entire dispute is whether there is an award existing.
Yes, respondent, why you are not filing affidavit? The only thing is whether there was an award there or not.
The
If an
earlier
award has
litigation
been
also-
passed,
We filed an affidavit.
No, the
There is
government
no
not
case
you.
affidavit.
No, Lordship, we have been directed to bring the records, Lordship. The record is gone through, Lordship. It's a voluminous record, but that relevant.
don't worry.
No,
It
Lordship.
takes me 2 minutes to look
No,
into.
no, Lordship. That relevant portion is not there accordingly.
Then that makes that submission, not the
Lordship, I'm
voluminous,
coming-
the
I'm-
relevance portion
Lordship.
is not there, which is
No,
relevant.
Lordship, that is why.
Make that submission.
A
Don't come up with this submission that the records are voluminous.
No, Lordship,
My
that the
goodness.
record is voluminous, that is true, and that part is not available, that is
That
also
is the
true.
most pertinent aspect.
And in this case, our senior advocate, Lordship, Dinath is appearing. He is on Lex Lordship. He is praying that 7 to 10 days time is.
31st, 31/8.
Yes.
Released the matter on 31/8/2024, on
Lordship.
which date the DC, which one? District Commissioner, which?
The District Commissioner Dibrugarh.
Dibrugarh.
Dib-
Shall bring on record their stand as to whether any award has been passed in
Yeah, it
land
should be.
acquisition case number, land acquisition case number
2011.
192/2011.
There are two, 192 and 193.
192/2011 as well as LA 193/2011 on or before 31/12/2013 or after 1/4/2014. The records also be produced without fail on the next date.
That is
31/8.
31/8, Lordship.
Yes,
Lord.
Saturday.
Much okay.
There's an interim order admission,
What is the interim order?
not to give effect to the impune order of 22 crores the compensation. We have already paid an interim amount of 9 crores as per the honorable court's order. there is a award upon us to pay 22 crores.
So
that
what
order-
will they do? They can't do anything. If you don't pay, what will they do? They can't do anything. Don't worry. These type of interim orders are not envisaged.
That order is not to be given effect to that kind of a interim order is there.
What order? Tomorrow the deputy commissioner asks you to pay the 10 crores or 15 crores or 20 crores. If you don't pay, what is he going to do? Go to Baki Jai?
Disbursing authority.
Order is
We are
under-
already disbursing authority.
It is
If
only
they
a
don't pay-
disbursing authority. He will only come up and what is he going to do? He can't do anything.
That award.
He
is
has to
taken
come to
care
the and ask him, then this court can do
Lordship.
anything. And then he has to go for execution.
The issue of interest may come in.
Interest is there.
So, because of
No,
the stay order-
no, nothing. Interest. Should I record that submission and say that because of the interest you are asking for stay
I was,
and it is vacated? Don't
I'm
come
just
up with
trying to
them.
place that there is an interim.
Nothing.
order.
Ask the second gentleman who is on after you to come. Your matter is over. Go. Okay, my goodness. Stay of this kind. Mr. Nath, kindly produce the records and get your affidavit filed. What I have said. 31
Wait, wait, Lord.
Yes, yes.
My lord, these are all particulars petitioners, my lord. In the national highway from Goripur to Dhubri, my lord.
Ah,
But just adjoining the national highway, my lord.
Hmm.
They have the patta lands, my lord.
ah.
Now, my lord, there was an order, impugned order passed by the deputy commissioner,
Hmm.
which says, my lord, no activities like construction activities are allowed. Because of the fact that river Gangadhar is flowing, but we have put it on record and it has come on the affidavit also. It is at least
Reported
50
that the
kilometers
wetlands,
away, my
water
lord.
bodies of so and so identify the land along the roadside. and- Yes, what is this? Very challenging.
My lord, we are just impugning that order at page 98,
Why?
98 of the deputy commissioner, my lord.
Why?
This order restricts us from making any construction or that building and all these things.
Where?
In the adjoining land to the national highway, that is from Goripur to Dhubri, DK Road. This called DK.
You have such a big land.
So many of the petitioners had, my lord.
How many petitions are there?
There are 9.
And everybody has a permission.
But yes, there.
You need a permission by
Building
laws,
permission, my lord.
building by law. Everybody has a permission.
Because of this order, my lord, no permission is allowed.
So then this is not a question of construction. It is a question of not granting you a permission. Then have you made those people a party, the permissioning authority? It has to be given by the municipal board or the panchayat.
By the deputy commissioner, my lord, we have.
Deputy commissioner doesn't give the
we-
permission for
representatives
construction.
are there, my lord, that
Huh?
has not been from the affidavit. They say that representation is still kept in abeyance. My lord, that representation may be, my lord.
Oh, I'm not post box. No representation.
That at page 100, my lord, there is a representation to that deputy commissioner, my lord. But their affidavit says it is kept on abeyance. My lord, that may be. It says that the representation submitted by the petitioners
Yes,
are being
Mr.
reviewed
What
and
what
kept in
kind
abeyance.
of order is this? Why you have passed this order?
My lord. Because there are some wetland nearby. There sinkage of wetland because of their land filling.
Ah.
Therefore, it is only after preliminary survey only, we have stopped it for the time being.
This is done under the disaster management. And this was done for the time being.
For-
But time being cannot be for 1.5 years.
My lordship may direct the deputy commissioner. We have filed our affidavit.
What do you say? Is it
that
for
it
time
is,
being? What do you say on the affidavit? Because that would amount to taking away the right for construction.
At page 9 of our affidavit, my lord. internal page 9. And it is submitted that the impugned order dated so and so by DC Commissioner regarding restriction on art filling, construction activities, etc. has been issued on the basis of the preliminary survey report by Land Revenue Office.
Then what are you going to do?
Keeping in mind the rapid change of the ecological balance of the Dadar Jarga bill and its shrinkage due to the rampant art filling activity. Common order was issued without specifying any patta holder or dao. Means the demarcation of the extent of the order will have to be
No, no,
finalized.
Mr. Talukdar, I understand everything, but what are you going to do at the end?
We will have to.
You have made a preliminary notification, then what are you going to do?
Then we'll survey the entire area, whether it's a dark patta land or it's,
Then what are you going to do? The next steps?
but we may restrict them.
No, restrict, you cannot restrict their
No,
right of use.
When if it falls under government land, we have.
No, the government land, as could be seen from the affidavit, is only 71 bighas. What about the other? How are you going to take care of them?
That has not been demarcated as such.
That has to be something has to be
My-
there. What is the next course of action you are going to do? We'll have it next time.
It doesn't say in so many words.
Because
Not
this
in
court
so
is
many
not going to appoint, because does the disaster management department, the act give you any power to do that? Or for that matter, any provision of law gives you a permission to take over, allow or the directs they shall not construct or do anything, fill up their land. Because they would be deprived of the right of use. Don't you think then in that regard, you
this
may have to
moment-
acquire that land?
At this moment, I cannot say anything because.
Understood,
it is not
but you
in-
cannot say, you can't keep it because they have a right to enjoy the property. They are not being able to enjoy it, isn't it? Mr. B.J. Talukdar, the council appearing on behalf of the revenue department.
This,
Oh, revenue has to come up. This disaster management. Ms. P.R. Mohanto as well as Mr. B.J. Talukdar, the learning council appearing on behalf of the respondent shall apprise this court on the next date as to what further steps the authorities are going to take pursuant to the preliminary survey report by the land revenue officials. This court would also like to be apprised on the next date as to whether there are any provisions by which the petitioner's right to enjoy their property can be restricted without following the due process of law, or can be restricted, which have been alleged to have been done by the impugned order. List the matter on 31(8). Disposal.
Okay, sir.
Get your instructions.
Party.
Yes, what is this?
Lord, here in this case, the coordinate wins of this petitioner is not in. But against that, my lord, the appeal has been filed. Appeal is admitted.
Appeal?
It appeal has been filed.
Order stayed? Missed.
Withdraw my
Withdraw. Withdraw. You may have a right of appeal. You are dismiss it. You want to withdraw.
withdraw my-
So and so the learned counsel appearing on behalf of the petitioner submits that the petitioner not like to press the instant petition in view of the judgment passed by the coordinate bench of this court in the case of Monisha Khatun versus so and so. Dated so and so. Accordingly, the instant writ petition stands closed on writ petition. This court, however, observed that withdrawal of the instant writ petition shall not preclude the petitioner to their entitlement in terms with the Motor Vehicles Act 1988. Oh, this matter. Somebody wanted to take time. Yes, what is this?
Some they have challenged the notice inviting to infraction. If this matter has become infractious, my lord, in view of our affidavit file in this case.
The NIT stayed.
NIT state, we have cancelled it, NIT. We have cancelled them.
Now,
Now, so this matter has become infractious. We have been cancelled and
release the matter tomorrow at 2 p.m. Oh, well, the Friday at 2 p.m. You get this instruction. Today, this person wanted to take an adjournment in the ground of Mr. M.Z. Ahmed. I declined it, but as he is not now, although it is still court's time, I would not like to lose
as it is, it has become infraction. Is it
2 p.m. Yes,
Lordship, if the matter can be taken up, Pathak have some medical
who's
Pathak. Pathak,
B. Pathak? What happened?
yesterday night he was
Comment, you have instructions?
yes.
What do you
Although the
say?
land is outside, my lord, this is the exception. But it falls within the zone of eco-centric.
Then put it by way of an affidavit. Mr. B.J. Talukdar, the learned counsel appearing on behalf of the district administration submits that he has received instructions which we would like to put in by way of, bring on record by way of affidavit. Was to list the matter again on 23rd of September 2024. The affidavit be filed on or before 17th of September. You file your affidavit by 17th. No, this same matter. Vehicle is identified. Oh, driver. Yes. Econo, dismiss the. Dismiss Monisha Khatun. Driver, econ vehicle number AS 072483, page 13 of this. Itu amar order to us, na?
Wait, your lordship.
What is this?
Petitioners filed an application before respondent number 2 for partition of their land. And number 2 forwarded it to respondent number 3, but they are sitting over the matter till date.
Respond number 2 forwarded to the respond number 3. And then,
Over the matter till date, they neither reject it nor allow it.
here's instructions.
Lordship, we are awaiting instruction.
Okay, Mr. B.J. Talukdar, the learned counsel appearing on behalf of the district administration submits that the instructions are awaited. It seemed that the notice in the instant case was issued on 15/11/2023 and earlier also on 15/7/2024, time was taken for obtaining instructions. This court fixes the matter again on 2nd of September 2024, on which date the respondent shall ensure the instructions are produced before this court. The counsel for the respondent shall ensure. Failure to do so, this court shall be constrained to seek the personal appearance of the counsel of the concerned officials. Yes, what is this?
Due to medical emergency, my lord,
Huh?
Think council, I will send to hospital, my lord, due to suddenly pressure is so high. my lord.
Okay, at the request of, anyways, we'll do one thing. What is this?
I will send.
Instruction is awaited, my lord. I may be allowed some time to file a.
Instructions awaited?
Yes, my lord, because they have served us copy lately, my lord. We have communicated. Instruction is awaited, my lord. 2 weeks.
I've copied recently.
Yes, my lord. Because last occasion, my lord, we received copy only on
Yes.
10th, my lord.
The instructions, Ms. Emborman submits that the instructions is awaited. Your also instructions are awaited, the council appearing on behalf of the respondents submits that in view of the late furnishing of the copies of the petition, the instructions are awaited. To list the matter again on 4th of November 2024. In the meantime, the respondents shall bring on record their stand by filing the affidavit.
If you will.
Yes, what is this?
There is a policy decision of the government, my lord, the person who died on the road accident, my lord, 2 lakhs rupees is provided, my lord. That's the policy.
Dismissed. That number to the আছে না গাড়ি?
Yes,
No, Mr. Secretary, dismissed. No,
as per your lordship's order.
no, Justice Surana's order. However, liberty is there to entitled for Motor Vehicles Act or not. The order is there. It says that one cannot get if you are, the vehicle is identified. You can very well get your benefit under the Motor Vehicles Act.
Earlier occasions, my lord.
Earlier occasion is
It's,
gone. Now the coordinate bench has
lordship
given.
passed the order, my lord.
Very well, but that is only for verification. Verify and pay. But when the coordinate bench have already held it, that a person is not entitled, this policy cannot be brought within the fold. And in fact, now the government has also come up with a circular to that effect. It is given in that judgment.
I'm not seen it, my lord.
Okay, I pass that order. File appeal. Yes, somebody else. Yes, Mr. B. Gogoi.
We have filed the affidavit yesterday.
The B.
Regarding
Gogoi.
supply of
yes.
dietary article. to the
Huh?
Nalbari- Supply of dietary article to the Nalbari Medical College, my lord. So Lordship will give a date, my lord, after 2 weeks. So in the meantime, let them file the reply. Can be, my lord, for that.
No stay.
No, my lord.
What is the matter? They are asking for money.
No, my lord. The tender was initiated, my lord. Subsequently, it was cancelled.
Huh.
Petitioner was found to be L1 bidder. So he has challenged the cancellation order.
There is no stay.
Okay. You have gone for the.
You have an urgency.
Yes, my lord, because.
We have it on 31st.
Yes, yes, my lord. Yes.
A fixed very less matters. Finish it off. It has been submitted by Mr. B. Gogoi, the Learning Council for the Health Department, that the affidavit has been duly filed yesterday on
On 30.
Good stop. Ms. So-and-so appearing on behalf of the petitioner submits that she would take the due instruction as to whether any reply the petitioners would like to file. List the matter, Mr. B. Gogoi expresses urgency in the matter. Taking into account the above, list the matter on 31/8/2024 at 2 p.m. and on which date an attempt shall be made to dispose of it. Yes, Mr. B. Gogoi.
My lords, I have been enrolled my lord, by an order, but I don't have the copy.
Oh, yes,
Yes.
instructions.
Lord,
Whether it has
I
been
just
notified.
went through the petition. Issue is not whether it's gazetted or not, my lords. Issue is, does the circle officer has the power under that? If it is gazetted also. Because it's a power, if my lord sees the notification, it's passed under my lord section, under section 17 sub J by the, under the air pollution control. So the
Where?
power lies with the,
Where is the impugned order?
page 39, 30, 39, 39. 40.
With reference to Subject, I'm
40
titled
pages.
to include herewith the inquiry report regarding violation of the norms of so and so by. There's the report. You are saying about violation of the norms of air can be the reason if it is not notified.
Yes, my lord. And my lord.
No, no,
is-
no, no, you do whatever maybe, so for whatever good grounds you may have, you take it. I'm not on that. But if your, or a public order has to be passed, taking into account something else, that needs to be under all circumstances.
Yes, my lord. Yes. That I understand. my lord. That
If it is not
my lord,
notified.
my lord.
You made it.
Yes.
You take whatever it is. If it is not notified, we set aside this order. However, liberty is given to the
Yes,
authorities
my
to
lord.
do.
But what had happened, my lord, the circle officer doesn't have the jurisdiction also. It's the state pollution control board, my lord, which will pass these orders.
Where?
And my lord, the section 21 of the prevention.
No,
Act, my
no,
lord,
no, no. We are concerned with this order at page 39. What does this additional district magistrate have this power?
Even this person also, this authority does also have the power. It lies with the
We
state
set
pollution
aside this
control board.
order.
This time, my lord, section 21 may be perused.
I know that section 21, you do have the power. It has to be exercised by that authority. These two authority have no business.
These two authorities have no powers. That I can say. my lord.
And that
In-
to this Assam Brick Cleans establishment regulation rules have not been notified.
Till now, I am, instructions have not come, my
No,
lord.
it cannot be so for
Yes.
such a long time. I have already observed.
My lord, but I found a judgment, my lord.
Huh?
A judgment of this honorable court, my lord.
What does it say? That the rules have been notified.
Rules not have been notified, but the issue cropped up, my lord, the constant difference between consent to establish and consent to operate. And my lord, those, it has it has scrutinized, my lord, the central rules, my lord. Those holds the field. Central rules, the Air Prevention Act of 1981, section 21 is there, which
Mr. Gogoi, you are appearing for which department?
Forest Department, my lord.
Forest.
Yes, my lord.
Does forest have anything to do with it?
No.
Why are you saying all this?
I was brought in, my lord.
Why you were brought in? Because somebody said about you. Otherwise, why will you
Yes,
have brought in? You said Mr. D. Gogoi Forest Department submits that he will obtain instruction
I was
on
I was called by the
17/7
court, my lord. I was called by the court.
Then what business you have? PCB, who is PCB?
Siddharth Borwa, my lord. as
Where is
the-
he? They are not doing anything.
They push the ball in my court because they say, my lord,
Yes.
I'm in our
Notified.
administrative department, my lord.
No, my lord, as per our instruction from the legislative department, my lord, that says that only that
That I know. Legislative department says that we do not know. It will be the administrative department who will know. Now the administrative department is nobody knows. You are the administrative department. Then list the matter, taking into account that none appears for the pollution control board
Yes.
today when the matter is being taken up. List the matter on 16/8/2024 at the top at 2 p.m.
My lord.
Dispose it off. We set aside that.
Yes, my
Only
otherwise
to the
also these authorities don't have power, my
no
lord.
business.
My lord.
Yeah, I understand section 21 and all these
Yes,
things they will do, but pollution has to do it.
I was brought in, my lord. Obliged, my lord.
Obliged.
Too. Oh, yes, what happened?
Lordship, as per the last order, the ADC has countersigned the certificate of
Yes,
caste.
Got it. Fantastic. See, something good has happened. Infructuous?
Yes, this is the eligible, but I find that from the side, my lord.
I have a legible copy.
The learned counsel, Miss M. Burman, the learned counsel appearing on behalf of the respondent numbers 1 and 2, submits that the additional deputy commissioner, which district?
Viswanath, my lord.
Sipsagar,
Viswanath, Viswanath.
Vishwanath, have pursuant to the order dated 12/8/2024, had made the necessary verifications and signed, countersigned
This side.
the caste certificate of the petitioner, no?
Yes,
Petitioner. Full stop. The learned counsel, and so in that regard, a photocopy of the said signed a caste certificate has been produced before this court. The same is kept on record and marked with letter X, taking into account above the instant petition stands Infructuous and accordingly closed.
Problem.
Yes, what happened? Anything?
The development, madam.
Nothing?
This Laskar is just trying to escape a sumo to contempt.
On one hand, I keep on getting, everything is being done.
There is some development.
What is the-
Today the child has been taken to GMCH for a checkup. That much I must admit. 108 was sent to Mongoldoid Civil Hospital. And the child has today been brought for a checkup to GMCH.
No, I
Apart
know, every month I get a data for a child. That is one thing. But this is not
Financial
happening.
part, my lord, the director is preparing the proposal, my lord, by next week, it will be sent to the government and they are doing it, my lord.
Okay, let us have this matter again on 11th of September. Mr. B. Gogoi, the learned counsel appearing on behalf of the Health and Family Welfare Department, admits that the proposal, the proposal as regards the financial sanction and all is in the process and would likely to be completed within 10-15 days. Who's list the matter again on 11th of September 2024. As regards the health, they are taking care of that. I've seen.
Just a tick. Keep your blessing.
I hope it doesn't become the state of the Sila Barse case, where initially it was with
Yes,
Justice Gogoi.
yes. I
Then
think
then it went to
that matter.
Justice Saikia. Then to you, I suppose.
Then to me, yes.
It's still
I think it is now closed, Your Lordship.
closed.
Keep
40,
your blessing.
Please. Lordship, as per the last order, Mr. S. Bora was directed to take instruction, Lordship. Compliance of the order passed in the read petition and acquisition matter, Lordship. Land was acquired in the year 2009, Lordship.
Mr. H. Sharma, where is he? H. Sharma's name has been shown in the cause list. I think it should be there. Huh?
Yes,
Huh?
Lordship. Yes.
This taking into account that why this thing has not happened, payment, this is the amount passed a long time back, no? I remember this case. They are not paying the amount. Which
It may
department is
kindly come to
this?
Page 15, Lordship.
Huh?
Page 15, Lordship. Direction of this on our report.
Chalo, we do one thing. We take up this matter on 19th at 2 p.m. Okay? Ask Mr. H. Sharma, his name duly appears, as well as those who appear on behalf of the respondent number 4 and 5 as to why the amount has not been paid. Else, ask these two persons, the Deputy Commissioner Udalguri or Principal Secretary BTC, that why we should not ask them to be personally present. I'm informing you. List the matter on 19/8/2024. Tell Mr. Esbora and whoever it is for the BTC. He is BTC. Wait, Mr. B. Chaudhary, you are BTC. You are BTC. This is a case where there was a direction passed long back in 2016 for making payment of the compensation. Nothing has been done. Yes, file representation, nothing has been done. I've taken up the matter. Government, I don't know what they are doing. The principal, Mr. Esbora, appears on behalf of the respondents. Tell him, if he does not come up with anything, I'm having it on 19th at 2 p.m. Court will initiate the contempt proceedings again, please. Here's what happened.
This message has been filed for restoration of connected WPC lordship for 1067. What happened, lordship? First came up before this honorable court for consideration.
Why? Why you appeared? Did not appear?
I went to CMCH for my treatment.
Huh?
Till I went to CMCH for my treatment. I've annexed the copy, lordship.
You went on GMCH on 23/6 and 14/8 specifically on the dates when the matters have been fixed.
I have explained, lordship, in the.
Oh,
Yes. On
come
12.
up with all these
The case
things.
was first. State
And
court-
how many lawyers were there? You
Okay, only-
attended,
only
admitted
myself.
on 19/2/2024 and
First came up for motion lordship on 20.
On 17/7/2024. Tell me, we should not dismiss with cost. How, why? 17/7/2000, the registered date is 17/7/2024. And the matter came up on 23/6/2020 and 14/8. Show me the document you were in the GMCH on those days. We should impose costs.
This petitioners came up for consideration on 27.
You were not, no. Why didn't you appear on 23/6 and 14/8?
Not lordship, 26/6.
23/6.
26 lordship.
23/6.
Lordship, on that day, in court number 10, I was appearing as a petitioner in person, lordship.
Very well.
there
And
was
when
a clash.
14/8,
On 14/8, escape from my notice, lordship.
then test.
Unfortunately. On-
Then why do you need it?
on answer,
Restoration.
Kindly have a look, page 14, lordship.
No case.
Page 14, kindly have a look. lordship.
No case, nothing.
Page 13 and 14, lordship.
Why are you asking 2 lakhs? Okay, you do one thing. Restore kori dibo. Restore kori petition dismiss kori dibo. Monisha Khatun.
In
I'm restoring this, dismissing that.
the retaken lordship, the Monisha Khatun case has been admitted and fixed for.
Stayed or not?
Not state lordship,
No, forget it.
but in that context, lordship, may I submit lordship?
I've,
in the
one
report-
one matter I have dealt with. Appeal. Have you filed the appeal or not? In one of your matters, in motion I dismissed.
Fine, lordship.
Fine,
In a reported case,
Let
lordship,
us stay. Let us stay. Then only I would not. As of now, I can restore kori. The ground of personal difficulty, third Mr. So-and-so submits that this is an application filed for restoration of the writ petition which was dismissed for default on 17/7/2024. Taking into account the grounds and which have been assigned out here in the grounds which have been assigned, this court restores the instant writ petition to the file.
may I submit lordship? One. I reported this lordship, 2019 GLT 3, page 636, your lordship has held that when a court is in region of a matter, an administrative authority cannot start a parallel proceeding on the very same aspect. Same principle is applied in this matter, lordship, since digital bench has taken the matter, so this honorable court may handle the matter.
Itu লেখো এখন itu dismiss করি
Achha.
Mr. Counsel, you need to read your law properly. When a matter is pending in Supreme Court, when the SLP is being pending, civil appeal has been admitted. Even if it's a case where a reference is made to a larger bench, the Supreme Court categorically says that unless there is an order of stay, you cannot say that you are not going to pass an order. See the judgments of the Supreme Court in that. If that is the case, when a reference is pending before the Constitution bench, when a matter is pending before the Supreme Court, when a case of a review being pending before the Supreme Court, then how does it matter when a matter is pending before the division bench? Yeah. Yes, eh? Tell me.
As per office note dated 23/4/24 and 12/8/2020. Service on respondent number 4 to 8. 5 to 8. My lord.
Why these courts don't fix a
Uh,
date? I don't
Condition
understand. What is
complete.
the matter about?
My lord, demarcation made by the circle officer and honorable court granted stay. Service has been completed.
Respond number 7 and APA, who's taking into account that the service is completed, list the matter again on 28th of August 2024. Interim order passed earlier shall continue only till the next date.
Awesome.
What is this?
The petitioners, they are claiming compensation due to illegal demolition of their houses in spite of court's order. The eviction notice is already set aside by this court. In spite of court's order, they have demolished their houses.
Who demolished?
Authorities. Lordship's order also there. Your lordship also passed.
Affidavit not filed, file. I respond number 1.
Get filed by the revenue has filed.
Huh?
Revenue has filed.
I have no role out there, my lords.
Who are you?
Forest is my department, my lords.
Forest is involved in all these things, nah? So they have presumed that the forest may be there. Like that court had presumed that you had something to do with the Assam bricklins. Something to the way. So they make.
I have nothing to do with this.
Huh?
Sir, affidavit, forest department has demolished.
Hello, anyways, you have been evicted.
Demolished.
Have the government filed affidavit? Anybody wants to
He
file?
is stating something which is not in record, my lords.
Huh?
This is something different. They're mixing up two issues. One
But-
is
No, the petitioners have alleged that the properties were demolished through illegal demolition eviction exercised by the respondent at the instance and the said illegal exercise undertaken under the supervision of the respondent number 9 and 10. This is the case of the petition. Affidavit filed by whom?
Department, paragraph 8.
No, revenue can, who has done it under, so who is respondent number 9 and 10?
And then your lordship. Forest department here.
Has the service upon respondent number 9 and 10 complete?
persons are being, my name they are.
Who is appearing for 9 and 10?
Had been my lord, by name I can appear, my lords. Is the DFO and one is the range officer.
No, you do one thing. Get your instruction as regards these two.
My lords, I can.
Can I put it that you will be appearing
Yes, yes.
and file a wakalatnama and affidavit?
Yes, I can.
Because the allegation is against you.
Yes.
That is why they want Mr. D. Gogoi here. The D. Gogoi, the learned counsel, submits that he has been instructed to appear on behalf of the respondent number 9 and 10. Full stop. He submits that he would like to, he has been also instructed, he would be filing the power on their behalf in a week's time. He further submits that he requires 3 weeks' time for filing their affidavit. Full stop. It is also seen that the district administration have also not filed their affidavit in opposition. Accordingly, list this matter on 23rd of September 2024. The affidavit be filed by the respondents on or before 17th of September 2024. The petitioner is to advise thereafter will be at liberty to file the report.
Four. Therefore, this time to file a affidavit.
Huh?
On behalf of the Assam Pharmacy Council.
Assam?
Pharmacy Council. Regarding my election, there is some objection regarding the election.
Mr. B. Gogoi, appearing on behalf of the Pharmacy Council, submits that he would be filing the affidavit within 10 days. List the matter again on 18th of September 2024. In the meantime, the affidavit will be filed by 6th of September. The petitioner, if so advised, will be at liberty to file the reply.
May I please, Your Lordship?
What happened?
Lordship, may I please peruse page 15. The Lordship had passed this order.
But application for praying for extension of time to file application before the deputy commissioner seeking a reference in terms with the order dated so and so, passed in so and so. What is this?
Lordship, that's
Why haven't you filed?
Lordship, I was not aware of the case. The order was passed in my absence.
Which order?
This order, where this extension was. Lordship, may go peruse page number 15 for all.
None appears on behalf of the petitioner.
Yes.
Then
So Lordship, after going through the petition, was pleased to page 718, paragraph 7 is the portion.
in 42 days from the date of the instant application.
So-
Then when did you come to learn?
In May 2024, because we had engaged the advocate S. N. Sharma. After his expiry, we have given all the details in paragraph 3 and 4.
Hmm.
So if Lordship peruse paragraph 6, Lordship, paragraph 6.
You don't appear, that is at your peril.
Lordship, I was not aware of the only extension I am seeking is that Lordship was pleased enough to run me time for 42 days. I came to know and immediately I filed this application. I'm seeking just a 3 weeks accommodation, 20 days. That 42 days, another from this date, just 20 days. That's the only accommodation. I'm not seeking any other relief.
How is it possible? Why is 42 days given, not 40 days? Tell me. Why 42 days? The 42 days is given because it is 6 weeks. 6 weeks is the mandate of the law. How do this court extend? Tell me. Give me a good reason. This court has to go then, because at that point of time we took it up, that it is an award being passed now and as such. You bring that appear very well. He doesn't get some money, ask your client to file a money suit against you. Where the client?
Lordship?
Where the lawyer?
No, I was not the lawyer.
Who was the lawyer?
Lawyer, senior advocate S. N. Sharma was the lawyer.
Okay. Ask his from his legal representatives. Ask the money. Your client to file a suit against him. Can't be none. Your names have been shown. How many persons' names were shown? In the cause list?
Cause list.
When they appear, it's a different aspect. I'm not bothered with that. Mr. K. Kolita is there. Why was he not appearing? Name was duly shown. It's something like you are asking for a review. How can this interlocutory application be filed? Tell me. In a disposed of matter? To file a review. Say that I was not present and detained. Interlocutory application, how can you file in a disposed of matter?
I was seeking for an extension only of that 20.
No.
That was the only prayer that
Better
was.
ask Mr.
because-
K. Chaudhary. Who is K. Chaudhary? He's the senior counsel.
Okay.
Ask him to explain how is it possible.
Lordship, then a date may be fixed.
List the matter of the 4 weeks.
Lordship, a short date may be fixed.
Why?
Lordship, already the delay is there, so any date next week, any date.
Yes,
Check
Mr. Garodia, what is it?
Lordships, my lord, we have instructions to oppose this application, madam.
Who are you?
Lordships, I'm for the airport authority, madam. Respondent number 5 and 6, madam.
You file your objection? You file your objection?
So,
Mr. P.K. Garodia, learned counsel appearing on behalf of the Airport Authority of India, submits that he may be given some time for filing objections. List the matter again on 31st of August 2024. In the meantime, the objection be filed.
Deeply obliged.
But you have a problem. 87 Supreme Court. Have a problem. You cannot. This is a fresh cause of action. 40? Yes. Again, same order, Aji Kumar. You want the striking off. Hey, Aji Kumar, case of order, this is not for striking off. And because this is, they have no business out there. Your petitioner is you. You file an application, file a fresh memo of parties, removing their name. Okay. Petition kon jiya ase di.